Got it right in front of me. Wallace? Do I need a prosecutor for this one? Do I need a prosecutor?
Okay.
Are we ready on Williford?
Yes, Your Honor, ready.
Good morning, counsel. Your appearance for Mr. Williford.
Good morning, Your Honor. Leanna Belcher on behalf of the defendant. Sir, please state your name for the record.
Good morning, Your Honor. Mario Williford.
Good morning, counsel. What do we got?
Your Honor, we have a grow-well license not valid that was in warrant status. I'm asking for the warrant to be recalled. My client is in the process of trying to take care of his outstanding tickets so that he can potentially resolve this with a plea. I'm requesting another pretrial date.
Okay, so the plea agreement I've got for a guilty plea is going out the window.
Must be, I didn't know.
Yeah, Judge, they want him to plead as charged. Our hope is, and he's paid, I believe he said around
That's all right. You
2,700.
had me at hello. I'm just confused by the paperwork I'm looking at.
At 9:10, Leanna is already MIDC that day with Judge Martin.
All right, April 23rd. What time? I'm sorry.
9:10.
So that's a Zoom?
Yeah.
All right. You got that, Mr. Williford?
Yes, sir.
All right, we'll mail you a notice. Counsel, anything else today?
No, Your Honor, not on this matter. Thank you.
You're welcome.
Thank you. Your
Oh,
Honor. Thank
Mr.
you. Once again.
Williford,
Yes,
you owe us money.
I know.
Are you working?
No, not at the moment.
When's the last time you worked?
Last week, I'm returning back to work. I just had got out of jail, so that's why I'm not working.
Okay. Can you commit to some kind of regular payments, either weekly, bi-weekly, or monthly?
Yes, I can.
Well, how do you want to do it? How much? How often? When can you start?
Bi-weekly, and I can start today or whenever.
You tell me.
Today,
How much?
I can start off with 100.
You're sure?
A positive.
All right, you gonna do that online then, or you gonna come in?
I can either one.
Say again?
Either one, but I can do it online.
However you want to do it. All right, I made a note. Good luck.
Thank you.
Thank you.
All right, appearances
Thank you,
on
Tony.
Wallace, please.
Attorney Davis, I repeat for 674 about John Wallace. Stands
All right. Thank you. All right. What do we got today?
Motion is pressed, you're on, let's go with Carter, follow response. Hearing.
I don't know that I've seen the response. I don't think I've seen it, and it's not in the file. Do you have a copy? If- let me have it. If you guys just give me a few minutes. Yeah, sure. Let me go through that and then we'll talk.
You just- One smaller.
Is it on June, Henry?
Yes.
Rated, Zoomery.
Okay. All right, ready for argument. And you guys don't have to jump up.
Your Honor, this case, just briefly, my client was stopped walking down Will Carl. The police came upon him because of two 911 calls. One is suspicious because it came from my client's own phone, from a distance away from someone else's house. The second one is a valid 911 call. Valid, it's credible because the caller gave his first last name, said saw someone walk down the road, looked intoxicated and stuff, where they used to call. Neither of these calls put my client behind the wheel of the car. The first one says there's a car in a ditch and there's someone on one road and there's someone walked down another. The police come, they talk to Wallace, and he makes some statements that that's what ends up getting charged with operating while intoxicated. He was never Mirandized, but even if he was, doesn't really matter. The statement by Mr. Wallace made during this interrogation are in this law lesson voluntarily, knowingly, and intelligently waived his right to self-incrimination. They must have been made with full awareness of both the nature and the right being abandoned and the consequences of the decision to abandon. The people quote Bergamo and Oregon as stating that the police don't have to Mirandize people on traffic stops. I understand that argument. I've made it myself before. The difference here is that the people completely ignore Cipriano and Stewart. And Cipriano, there's 11 factors looking at whether or not the statement was knowingly made. The age of the
Hold on, that's two different issues though. First is, should they have Mirandized him? And your argument is Miranda or not, the statements aren't usable. Yeah, so let's not mix those two arguments. Right, let's talk about first one first. Let's talk about whether or not they should Mirandize him. Unless you want to just skip that one.
I'll skip that one because I think Bergamo and Oregon control on traffic. So
Okay.
say this is a traffic stop. They were walking down the street. It's more akin to a Terry stop than a traffic stop. But even if he wasn't Mirandized, I think Cipriano and Stewart control that, because Cipriano looks at whether or not constitutional advice would render whether the person is Mirandized. It's one of the factors, and none of the 11 factors control in and of themselves. Cipriano looks at the totality of the circumstances, so they look at all of the factors together along with everything else. So whether or not he was Mirandized, I don't think is the issue here to allow you to suppress the statements.
All right, then let's talk about the other factors.
In Cipriano, the control are the age of the defendant, the extent of the prior police contact defendant has had, lack of constitutional advice, injury, intoxication, or ill health of the defendant, and if you deprive of food, sleep, or medical assistance. My client Mr. Walsh was 22 days away from his 21st birthday on the date of the stop. Stewart was an 18-year-old. There's not a lot of difference between a 20-year-old and an 18-year-old, I believe. He was young. He didn't know because he's not development's in brain, not complete yet. He's not a juvenile, but he's not an adult. Fully formed. He hasn't had any prior police contact. He's not aware of his rights completely. He wasn't Mirandized. He was highly intoxicated. And he was potentially in an accident. He did ask for medical care. He was taken to the hospital. The blood draw feedback was 0.25. It's exceedingly high. It's 3 times the legal limit to draw. I find it difficult to believe that you can say you're too intoxicated, but yet we're going to take every statement you say against your own self-interest as the main. When you add in, you take all of that and you add in the facts of the first 911 call, I included an affidavit in compliance lawyer. The people say they don't understand the reasoning for that. The reasoning for that is, Ms. Wallace, when retrieved Mr. Wallace's phone that day from this other individual, Mr. Smith, who I believe made the phone call. I believe the phone call was made from that phone for two reasons. One, there's a screenshot of my client's phone saying it was used to call 911 with less reporting on August 2nd. And two, when you listen to the 911 call, the individual who says his name is Brandon is talking to the 911 saying that there's a car in a ditch. It's a 300 Chrysler, it's black, and there's someone walking down Will Carlton Road. While he's making that phone call, while he's making that 911 call, an automated message from Mr. Wallace's iPhone breaks in and says, the owner of this iPhone has been involved in a serious car accident. They're not responding, and they give GPS coordinates. And those GPS coordinates just happen to be Mr. Speed's house. So there was another person in the car. It's entirely possible that Mr. Spino was the driver, put the car in the ditch, and took off with my client's phone and made this phone call at a later time. That's reasonable doubt for a trial. I understand that. But when you look at that and you put it all together, there is reason to doubt my client's statement because of his level of intoxication, because someone else was there and was potentially driving, because no one saw my client driving. I believe these statements should be suppressed. I believe that they're not credible based. And without these statements, there's no one to put it. Mr. Wallace operated the vehicle.
Anything else at this time?
No, you're.
Madam Prosecutor?
Statements such as I parked it there, I just sat there and I figured I would just walk the rest of the way and get it towed. I ain't going to bullshit you. I am obviously way too intoxicated to drive, and that's when I stopped. The defense wants us to believe the defendant was still undergoing physiological and neurological maturation, was unable to fully understand or appreciate the situation and the statements that he had made. If we were to apply this standard, then all men in their late teens and early 20s would be given a pass to commit crime up until their prefrontal cortex had fully developed. The defendant made multiple decisions that day. He made a decision to drive drunk. He made a decision to make these statements. He made decisions such as electing not to complete field sobriety tests. He made decisions not to. When asked where he got the alcohol, he told police that he didn't want to tell them. He made decisions such as when they asked what friend's house he was heading to, he elected not to tell them. He made all of these decisions that day. I find it hard to believe that he can make all of these well-informed decisions if he wasn't able to fully understand those statements, such as I parked it there, I drove, all this other statements that he made as it relates to driving his vehicle, but can't appreciate the statements such as not getting consent to do field sobriety system or a PT or anything of that nature. He also told police that he knew his laws. He told police that he came from a background of law enforcement officers and was making very clearly informed decisions based upon the situation.
Respond.
Yes, Your Honor. One, I don't believe that you can take one instance, this case in particular, and paint everyone's getting a free pass for committing crimes because they're not over 25. That's not the point. My point is looking at his age, it's one instance of the Cipriano factors that goes towards the entirety. So we're not saying that everyone gets a free pass because they're not fully formed yet. That's a broad generalization of people, not our point. Again, age being one factor, the level of intoxication being one factor. You could have said kill the defendant, it doesn't. So I think that everything needs to be looked at much more closely and not just cherry picked. Well, he said he was drinking driving, so obviously it wasn't. When there's no other corroborating surface, no other corroborating evidence whatsoever, not even the 2 911 calls put it in the vehicle. That I saw a guy put his car in a ditch and now was walking down the little car. That would at least be some circumstantial evidence that he was operating the vehicle. People also raised the fact that the car was tied to his mother, that one of his credit cards was in the car, and that he had the key fob in his pocket. So, obviously he was driving. Having a key fob for a new model car doesn't mean that you're operating. It means you could be sitting in the passenger seat, and someone could push the start button, the car starts. You could be next to the car, and someone pushes the start button and it starts flipping, you're operating. Looking at everything, again, looking at the totality of the circumstances, including the first suspicious 911 call. I believe causes a credibility issue with the statement of a 20-year-old who had a 0.25 BAC.
Anything else? Let's talk specifically about Cipriano and how it applies to these facts.
So let's see. So the age of the accused, the defendant was already shy of 20 years old. In my investigation, at the intelligence level, I understand that when he told the police, he explained that he had a lucrative career as a sort of customer or contact with her, or what have you. He obviously knew, he told police that he understood that he could not drink. He understood that he should not drive when he was intoxicated. He had knowledge and wherewithal to know that these things were wrong. The extent of his previous experience with the police, I know that he had no priors, so I have no reason to believe that he knew, but he did know they were police, they were fully uniformed and what would identify themselves as police officers. Going to the detention of the accused before he gave the statement some question, he almost immediately stated that pardon to you. He went on to say all the other statements just within the first couple of minutes of interaction with the police. The lack of any advice to the accused of his constitutional rights. Again, he knew that he told the officer that he knew his laws, that he had police background or to his family. He made decisions such as not doing the PPT, not doing field sobriety.
How's all that fit Cipriano though? The fact that he made decisions, how's that fit Cipriano? I understand his statements that he knows law enforcement, he knows cops, whatever, I know my rights, whatever that is. I understand how that would fit to his educational level. But how does all this other stuff you're giving me fit Cipriano? Having made other decisions?
I mean, well, there was, I'm sorry, the lack of any advice to the accused of his constitutional rights. Because he knew that, he stated that he knew the laws.
Right.
Like knowing laws, knows that he can say no to certain things, such as the PPT and those practices.
Okay. Anything else you want to say about Cipriano?
I think those things remain factors if you wish.
If you think they help you.
I guess we can start where whether the accused was injured, intoxicated, or drugged and in ill health when he gave the statement. He did have a very, very, very high case. Was intoxicated, but frequently in the other case, people are intoxicated. That is probably 15% of traffic stops are drunk driving. In order to investigate drunk driving, you have to ask questions of the individual. He did tell the officer that he needed some sort of medical intervention about half an hour into the investigation. Officer McNally immediately called for assistance. Officer Seki was on scene. He is a trained and certified EST. The defendant could not articulate what was wrong with him other than not feeling well. I think that would be the last one.
Okay. All right. Anything else?
Yes, you are. I understand that the voluntary injection of new alcohol substances, alcohol and drugs isn't, a defense between, so we're not talking about whether the crime was committed here. We're talking about the statements that were made that would link my client to these charges. And again, I think it bears repeating, a 20-year-old with 0.25 alcohol beyond and underage drinking, everything else goes along with it. I think looking at taking that into consideration with his statements, who knows what he's saying is true, and there's no other corroborating evidence to put him behind the vehicle operating. All you have is these drunken statements with no other proof. With that, I believe statements can't be looked at as credible.
Anything else? Anything else?
No.
All right, it's a close call, counsel, but I'm going to deny your motion. I encourage you to appeal it. Anything else?
No.
Good luck. Why am I doing an arraignment on line?
Here, Judge Patton's arraignment.
Is this one of them? This one that I got Ackman, that Jamie handed me?
Must be, yes.
Oh, okay.
Yeah, he got, I think it was the letter that we got, I don't know, his file, we've got.
I only have this one. Are we ready on Ackman?
Thank you.
Jane, you said I leave some.
Yes, sir. Judge, Wayne County is not on Zoom yet.
Those are arraignments on? No. Is Ackman at Wayne County?
Yeah.
Yeah.
Great, that's all I know. Aaron Frazier. Figure out what's ready and when, and I'll be happy to do them. Good morning, counsel. How you been? Haven't seen you for a while. Good.
Okay, just,
Keeping busy?
well, sponges lately, so that's been
Good.
lighter side of what we do.
Yeah, more fun, eh? Yeah. All right, so tell me about Mr. Frazier and his file.
So Mr. Frazier, he is, arraignment. Is it arraignment?
If it is, I'll enter not guilty plea and we'll move forward.
He's 40, some college, with Rambus High School. He has the dance and other practice in courtroom in Front Row.
Beautiful.
And Anthony Floyd has 5 children, 12 to 17. No prior drunk driving cases, state had prior suspended life. Something from Stephen Shield, highway jumper.
Okay.
So basically, he had this traffic and stop. And they said he had a high block. He was coming from his nephew's birthday party. They've given us some offer. Disobeying the traffic control device.
Yep.
Here, so I talked to him about it. We reviewed the discovery. I emailed him the discovery as well. And so he's ready to just go ahead and please.
Good. All right, Mr. Frazier, did you discuss your rights and options with counsel?
Yes, sir.
You understand those rights and options? You understand the possible penalty for impaired driving? Understanding that, are you pleading guilty to that charge freely and voluntarily today? All right, did you drive a vehicle in Sumter Township on February 14, 2026? Prior to driving, did you drink alcohol? Counsel, was there a blood or breath test?
Yes.
Would you stipulate?
Yes.
Results were? You think the facts have been met for the impaired?
Yes.
So do I. I'll dismiss the intoxicated or the high BAC and the civil infraction. Mr. Frazier, I'm going to send you downstairs to make an appointment with our probation department to come back for a screening. In the meantime, I'm going to put you on a personal bond. 2 conditions that are pretty obvious: stay out of trouble and show up for court. Third one is do not purchase, possess, or consume any mood altering substance unless you got a doctor's prescription for the substance. Can you live with my rules? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you screw up on bond? Any questions? Counsel?
You said you have a solar limit or something? Yeah.
Who's got him on a sober link? We don't have him on a sober link. You mean you did that on your own?
Okay.
Proactive, yeah.
Okay.
Yeah, make sure you let probation know that when you come in for your interview. If you go down, you'll have some input on picking that date. So go down to probation. All right. Have a great day, people. You're welcome. Delaware.
Ray, Your Honor. Good morning, Your Honor.
Good morning.
Record, Judge about 45367, appearing on behalf of the Mr. Water. Sir, could you tell the gentleman to make it record, please?
Thank you.
Your Honor, today is a big concept for bringing in this item, great form of ingredients. Also, I had a chance to pre-trial it. In prosecution, I've been with Mr. Delaware. We have executed plea agreement where Mr. Delaware would be the one count of having a dog at large.
Good.
There is a little caveat in there that the prosecutor wished that he agreed upon. He has to get his dog in some sort of training program within 14 days and provide proof to the court. If so, the matter would be taken under 771 for a period of 12 months. The other charge, Your Honor, would be dismissed.
Okay. Mr. Delauder, you understand your rights and options after discussing those with Mr. Bowditch?
Yes,
You understand the possible penalty for dog at large?
yes,
Are you pleading guilty freely and voluntarily, understanding all that? Did you have a dog at large on 12/7/25 in Huron Township?
yes.
Satisfied?
Satisfied, Your Honor.
Satisfied. I'll dismiss the companion case.
Thank you.
No prior criminal offenses?
No, Your Honor.
Working?
No.
How old are you?
20.
How come you're not working?
Been about trying to find a job.
Bullshit. How come you're not working?
Well,
You got transportation?
no, not really.
You got a driver's license? Why not?
Because I can't pass the test.
Where'd you go to high school at?
Black Hawk High School.
Finish? What have you done since then?
I've been trying to get my license, trying to find a job and
Dude, don't give me that. Don't give me that. Everybody I know is hiring labor. Everybody I know is hiring labor. I know a guy that owns 6 subways and he's working the line every day because he can't find people to work the subways. I know guys in the construction trade that are turning jobs down because they can't find somebody that'll show up and just do the backbreaking labor that it takes to do construction work. I'm putting you in jail if you don't have a job next time I see you. Clear?
yeah,
Okay. So we'll set a sentencing date. Give me a date at least 2 weeks out. When you come for sentencing, bring documentation of the training.
March 26th.
March 26th, how's that work? What time?
9 o'clock.
9 o'clock. All right, if you want some help finding a job, on the way out the door, go down and talk to Mr. Taylor downstairs, best dressed guy in the building. He'll give you some options locally that people are always hiring. But hear me, on the 26th, if you don't have a job, bring a toothbrush.
okay.
Okay?
Wait for no.
Range files, Judge. Thank you. Thank you. All right, have a seat. Alexis Baker.
Hey, Your Honor. Hey, Your Honor, for the record, after about 45367, appearing on behalf of and with Ms. Baker, ma'am, could you tell her from me?
Good morning, ma'am.
Your Honor, today's date time set for bringing in this matter, the way formal meeting and stand. We also had a chance to pre-trial this case, Your Honor. That's the subject.
Tell me all about it.
In that agreement, this Baker was pleading guilty to an added count of operating while visibly impaired and failing to accident with the understanding all the 4 original charges with the dismissed.
Did that young man have anybody with him today?
No, Your Honor.
He got your phone number? Catch him, make sure he talks to Mr. Body before he gets out of here. Where is he?
He's waiting for his notice.
All right.
Make sure you speak to counsel before you leave. They understand,
If you've got anything that I should know before I send you to jail, you talk to him about it. I just threw you a lifeline, brother. You're welcome. Go ahead. Counsel, go ahead, Ms. Baker.
Your Honor, you welcome to go out here.
Did we get to the plea yet?
Yes, sir.
All right,
Two charges, operating while physically impaired and failure to report an accident.
okay,
For original charges would be
voir dire.
the offense.
Hold on a minute. You understand your rights? You understand the options they give you? You understand the possible penalties? You're pleading guilty or no contest?
No contest.
You understand when you say no contest, you're saying, Judge, I'm not fighting those charges. You're doing all that freely and voluntarily? Do you have a,
Civil litigation.
do you have an incident report? Because a voir dire is not going to work with a no contest.
I think I think the prosecutor has it on his phone.
It doesn't do me any good. I got to have the facts. I can pass on the file.
Yes, sir.
Okay,
Fine.
all right. Ms. Baker, have a seat.
Let's see. Make sure that.
Just so that I can make sure that the
Schomer?
Your Honor, Tyler, the people 75702 on behalf of Mr. Schomer, can you say my last? Mr. Schomer, can I say your name for the record?
It's Kenneth Schomer.
Counsel, you want to adjourn the case ending in 386 A, B, and C?
Yes, sir, and that's not necessarily an adjournment, we're asking for a trial date for the final two trial.
Two different things in my courtroom.
We're asking for a trial date, I don't know if this court sets final three trials.
Why do you want a final pretrial?
I guess.
You're not getting.
Yeah.
This guy's been in the system long enough. What kind of trial you want?
Can you get Caitlin in here just so, or tell her to jump on Zoom if she needs to, I need to work on dates.
All right, so I think I got A, B, C. All right, those are files we're gonna set for trial. All right, he's got some other files he's got warrants on. Are you aware of that? All right,
Is that for the probation, Your Honor?
yeah, he's got two files that he hasn't done a damn thing I've told him to do.
And he's told me that he's completed all of the probation requirements, however.
Then you might want to you don't want to talk in front of me. You might want to talk to probation because I'm getting ready to put him in jail for 6 months.
Thank you, Your Honor.
I'll let you hold the files until you talk to probation. Because based on the information I've got, he hasn't done a thing I've told him to do. Yep. Counsel, we'll call probation, ask her to come up. You're welcome. Stephen Britt,
It was on Shelmer, for the jury trial date. And we'll call you back.
that's all right. Get something nailed down with her.
Oh, okay, yeah, bring them back.
Good morning.
Jay.
Are you going forward without an attorney today? You made a deal with the prosecutor? All right, so I've got 3 files here from November 6th. The prosecutors last year, 25. And the prosecutors asked me to dismiss those. I'm assuming that's okay with you? All right. That's the good news. The bad news is you owe us some money on some other files. Are you aware of that? Yeah, I'm dismissing 3 files that are ending in case number 995, ABC, but I've got 3 files ending in 824, also from 2025, also violation of technical requirements. 276 apiece. Can you tell me if those blue ones are civil infractions or not? By looking at them?
Yeah.
Yeah, so those are civil infractions. You can do that today? Go downstairs and pay that money, get a smile and get out of here. You're welcome. Last name is Britt, Britt. Amber Brown, come on up. Walk slow. I'm doing paperwork. Ma'am, are you going forward today without benefit of an attorney?
Yeah.
All right, when I'm done with this paperwork, I'm going to look at your paperwork and find out what we're doing. Looks like you probably made a deal today with the prosecutor. All right.
You turn the first shot and general what it's supposed to do. So follow the application, I didn't even say anything, I told you, yeah, legal. So.
Fill the attorney, and he's got our files. All right, let's see what we got. All right, so you're going to plead guilty to an added charge, allow unlicensed driver to drive, right? You understand the possible penalty? All right, and did you read your rights form? You understand those rights and the options they give you? Understanding all of that, are you pleading guilty to that charge freely and voluntarily today? Did you in fact drive a vehicle in Huron on January 7 this year? At the time, was your license suspended, revoked, or denied?
Yes, sir.
Actually, there's 2 civil infractions we're going to dismiss. Yeah, 2 civils, 1 original misdemeanor. Yeah, that's all right. You're just checking to see if I'm on my toes. That's okay. All right, so I will accept your plea to that added misdemeanor and dismiss all 3 of the original charges. How's that? All right, what's the status of your license now?
It is still suspended. I have to work at North Carolina.
Any idea what the plan is there?
No.
All right, is it a money thing or you don't even know? Okay, all right, are you working?
No.
Okay. So how long has it been since you had a valid license? Long time?
No. I just moved here in September, so it was pretty shortly before that. I've never had a suspended.
But you picked a bad winter to get here in September. All right, okay, yeah, it was a rough one. Okay, all right, anything you want me to consider before I sentence you today?
Just whatever I do need to pay to get me out of.
Okay. All right, so normally what I do on these types of files is I order work program as an alternative to jail time. So what I'm going to do is I'm going to order you to do 4 days on the work program. Go down and talk to our folks about scheduling based on whatever restrictions you may have, physical restrictions. We may be able to accommodate with work program, or if we can't, we'll convert. Are you listening? We'll convert the work program to community service, which is charity work. All right. So either you do days with us, depending on what you can do, or you'll do hours with some nonprofit. All right. Any questions on that part? All right. Money, it's $500 fines and costs. Can you pay that today or do you need options? Downstairs, you'll talk about options. Yeah, they'll tell you what all those options are. Any questions? All right. Good luck with North Carolina. I did a Schumer one. Yeah. Counsel, you ready on Schumer?
I'm ready, Your Honor. However, we don't have an appearance on the violation. I'm only on the impaired driving.
Okay. You're not representing him on the violation files?
We're not been hired on the one.
Okay, then Mr. Schomer needs to talk to Mr. Bowditch then. Because Mr. Schomer, you're entitled to an attorney to represent you on these files. I understand this office hasn't been retained, but I'll let you talk to Mr. Bowditch if you'd like to talk to him. All right?
Yeah. Yeah.
Kiara Dean,
Oh.
Miss Dean, are you going forward today without an attorney? All right, you made a deal with the prosecutor. Says here you're going to plead guilty to no valid operator license on person from May 29. Is that correct? All right. Did you understand the possible penalties for the new charge? And you understand your rights and options? Understanding all of that, are you pleading guilty to that charge? And are you doing so freely and voluntarily? All right. Ms. Belcher, arraignments are next.
Thank you,
All right,
Judge.
did you drive a vehicle in Huron on that date? Was your license suspended that day? I will accept your plea to the added charge. All right. Understand that when that no valid operator's license charge hits Secretary of State's records, they may resuspend you. You understand that? Okay. All right. And what's the status of your license now?
It's still, and I'm on the word.
What do you have to do? You owe tickets other places or what? How many courts you dealing with? 2 plus us. Okay, are you on payment plans there?
And then on it, actually, this month.
Okay. So can you see the light at the end of the tunnel to get your license back? When do you think you'll have your license back?
I'm due with August. I'm trying to get that done before August.
Congratulations. Okay. Can you do it a lot faster than that?
I actually have a job interview today, so I'm praying that I get that done.
All right. What are the chances of you getting your license, getting cleared with the other courts and getting your license reinstated within 30 days?
So
I'm getting ready to give you the deal of the century, but that might mean you got to beg, borrow and steal. Well, I shouldn't say steal. Beg, borrow and coerce money to get those other courts paid for.
I can try.
Okay.
I do have a lot of support, so.
Okay. Okay. All right. And you owe us money here on other files. Can you get some kind of payment plan started there? All right. But these, I don't think these are stopping you from getting your license straight. Yeah, we got a no proof of insurance. How are we doing that? Does that have to be paid? Does that get our license back? All right. So that's $438. We won't let you get your license back until that's paid. So, all right. Last name is Dean. First name Chiaro. All right. So anything else you want to, are you working right now? You said you got a job interview. Are you currently unemployed? Where's the job interview?
Actually virtual,
Okay.
caregiving job.
Okay. Good luck. All right. So anything else you want me to consider before I sentence you today? You're all right. You're all right. All right, so here's what I'm going to do. On this file today, fines and costs are $600 and 4 days on the court work program. I assess work program as an alternative to jail. So I'm going to suggest you schedule those and get them done. A, so they don't impact with a new job, and B, so you don't have to do it when you're more pregnant. Okay. Now, as far as the money, it's $600. You're going to pay that or show me a valid driver's license between now and May 1st. So if you get your driver's license and you can show me that, I'll waive the $600. I'm literally going to pay you to get your driver's license straight. Okay. Now, don't be afraid to come see me if you haven't gotten it all done before May 1st. Let's see where we're at. Okay. Pretty good incentive. Okay. That's worth calling grandma if you need to. Okay. All right. Any questions? So go downstairs, set up your payment plan on the money you already owe and tell them you want to know exactly what you got to pay to get us out of your way. I think it's the full 438. And then talk about the 4 days on the work program.
Okay.
All right. Good luck. Good luck. Miss Belcher, do you have a preference who we start with?
Dealer's choice.
I've got Austin Kitchens on top.
Okay.
Good morning, Romulus. Can we have Kitchens up?
Want to stand up?
Miss Belcher, would you waive formal reading for Mr. Kitchens?
Yes, Your Honor, and stand mute to the charges.
Thank you. We're going to set up a pre-conference PCC March 24. That's going to be with me. That'll be live. Right? We're doing live PCC. Yeah. All right, let's talk bond. Did you see the bond rec from the department?
Yes, Your Honor, I did, and I did review that with my client.
All right, where's he on probation or parole at? They didn't give me that.
Your Honor, my understanding is that's a HIDA probation out of circuit court. Is that
All
correct, Mr. Kitchens?
Yes, I just got it yesterday.
Oh, you just got sentenced yesterday?
Yes, Your Honor. I went to go get my tether taken off, and that's when they told me I had a warrant from out here.
Okay, so as far as you know, you're in compliance with HIDA other than what happens on this charge.
Correct.
You've done nothing else to violate your probation in circuit court, yes or no?
No, Your Honor.
That you know of? Okay.
Not at all.
Okay. Are you working?
Yes, Your Honor.
Where do you work?
I work at Jan Door in Dearborn. I put doors together.
Yeah, I know Jan. How long you been with Jan Door?
I just got laid off from the labor's union. I was in local 1191. I was working for Rudolph Libby. They laid us off during the winter. So I just started Jan Door last week because I needed something because I have a 8-month-old daughter I'm trying to take care of.
All right. So how long you been in the union?
I was in the union for about a year.
Okay. What else should I consider, Ms. Belcher?
Your Honor, he's 24 years old. The complaining witness, my understanding is that's an uncle. The address that's listed is not an address that the uncle resides at, so he would have no reason to have contact with him if Your Honor released him on a personal bond. It's a bit strange to me, Your Honor, that this warrant wasn't caught before he entered a plea because they could have done a global resolution for him. So he's in a bit of a bad spot just because things weren't caught in time. From my understanding,
I'm sorry, the circuit court case he's on probation, was that out of our court?
I don't know that it's out of your court, Your Honor. I know it's Wayne County.
He says no. Okay. All right. Anything else?
I believe it's the same prosecutor's office, so that's why it's strange to me.
Yeah.
He was in compliance with his tether before. He says he has no capious history. I know he has ties to the community. There's certainly conditions Your Honor can put in place to protect the complaining witness, such as no contact. For all of those reasons, Your Honor, I would ask that you consider a personal bond.
Yeah, I can consider it. All right, Mr. Kitchens, I'm going to put you on a personal bond. First two conditions are pretty obvious. Stay out of trouble and show up for your court dates. As I said, your first court date with us is March 24. We'll do that at 9:45 in the morning. That's live, my courtroom. We're also going to set a preliminary exam for March 31, my courtroom, 9:30, also live. Additional condition is that you have no contact with your uncle. That means no phone calls, no letters, no social media contact. He tracks you down and says, hey, bud, let's get together and have a cup of coffee. No, he doesn't change the order. Only myself or another judge with a black robe. You run into him at Taco Bell, you're eating Burger King. He does not exist to you until somebody tells you you can have contact with him. Clear?
Yes, Your Honor.
All right, raise your right hand. Swear or affirm and acknowledge the debt payable to the court in the amount of $5,000 if you mess this up.
Yes, Your Honor.
Any questions from me or Ms. Belcher before we terminate the meeting?
Not currently, Your Honor. Thank you.
All right. Good luck.
Thank you, Your Honor.
Thank you, Your Honor.
Romulus, do you have Donald Laramie there as well?
That's correct.
All right. Ms. Belcher, your appearance for Mr. Laramie.
Good morning again, Your Honor. Leanna Belcher on behalf of Mr. Laramie. Sir, will you please state your name for the record?
Donald Laramie.
Thank you. All right, we've got a couple different files for Mr. Laramie. Let's start with the July 30, 2024 B&E out of a vehicle out of Romulus. Would you waive formal?
Yes, Your Honor, and stand mute to the charges requesting a probable cause conference date.
Done. That probable cause conference is March 24 with me. We'll set a preliminary exam for March 31 with me. Let's talk bond for Mr. Laramie.
Yes, Your Honor. He's 35 years old. The address on the paperwork is a good address for him in Novi. He did indicate that he is employed full-time. He works as the GM at Powerhouse, and he also works on the weekends doing personal training. He has a 4-year-old son that lives in his home. His significant other is out of town for a month, so he is concerned. The aunt does have the 4-year-old son, but he is nonverbal, so it's imperative, Your Honor, that he get back to take care of his child. He indicated that his warrants are out of some district courts. Some of it's just a financial obligation, Your Honor, that he owes money for a probation violation out of Plymouth. These offenses, or this specific one, occurred in 2024, so there's been significant time since then. And he did indicate, Your Honor, that he's been sober for 2.5 years, so he's certainly turned his life around. I would request, Your Honor, impose a personal bond.
Thank you.
Okay. All right. So, Mr. Laramie, I've got 2 other files. We're going to talk about dates on those.
Okay.
That you missed court dates back on, well, it looks like early January 25, so a year ago. It looks like at that time your address was on Kensington.
I never lived on Kensington. That was a mailing address, and the person never got my mail to me, so I apologize about that. I never knew about it. If I did, I would
All right,
have
so
never missed work.
the reason you didn't show up for the court dates is because you didn't know you had court dates?
100%, sir.
All right, brother, I'm gonna give you a chance on a personal bind. Don't screw this up, because if you screw up, you're screwing up in front of me. I won't forget.
I appreciate you. Thank you, sir.
All right. All right, so on the felony file, 9:45 on March 24 is your first date.
Okay,
9:30 on March 31 is your second date.
okay. I'll
First
get
two
back.
conditions on your bond are the obvious ones: stay out of trouble and show up for court.
Yes, sir.
Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $5,000 if you screw that up?
Yes, sir.
Any questions so far?
No, sir.
All right, put your hand down just for a second. I've got a 9/20/2024 Van Buren misdemeanor charge, 2 counts. Would you waive formal reading on that one, Ms. Belcher?
Yes, Your Honor, and stand mute.
Thank you. I'll enter not guilty plea. Pretrial is going to be with Judge Martin on March 26, 10:50 in the morning. That's Zoom, Mr. Laramie. Understood?
Yes, sir. I'll get printouts of all this, correct, Your Honor?
If the officer is nice enough at the department to write it all
Thank you.
down.
I appreciate it.
Yeah, you'll get a copy.
Thank you.
Thank you. All right, I'm going to put you on a personal bond on that one, Mr. Laramie.
Thank you.
Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 on this one if you miss your court date?
Yes, sir.
Put your hand down. Last file I've got is a Romulus misdemeanor, January 8, 2024 is the incident date. April 2, 2026, 8:15 in the morning, live with me is your pretrial date. I'll put you on a personal bond on that one. Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 on that file if you screw up by not showing up?
Yes, sir.
Any questions for Ms. Belcher or myself?
No, sir.
You're all set.
Thank you, Your
Thank you,
Honor.
Romulus. Stay
Thank you, Your
safe.
Honor. Thank you.
And Ms. Belcher, who do we have in Wayne County?
Your Honor, I didn't receive any additional files for arraignments.
Judge,
Okay,
it's
Ackman?
Ackman, and he
Okay.
did not. He's shaking his head no, but that's the paperwork I received from the county.
all right. Mr. Ackman, can you hit the mute button there so I can talk to you? Well, so you can talk to me? Can you hear me all
She
right?
said I'm shaking my head. What I'm shaking, I don't know what's going on.
Well, that's all right.
Good
That's why I
morning,
wanted
good
to talk to
morning,
you, so I
Judge.
try to
Good morning,
explain you.
Judge Oakley. I ain't disrespectful. Good morning, sir.
All right, good morning. All right, do you want to talk to a court-appointed attorney for arraignment purposes? or
Ain't
do you wanna
nobody
wait
talking to
till-
me about nothing. I just got yanked out at the
Brother,
last one. I
that's
don't
why
even know
I'm
what's
talking
going
to you.
on
I'm
today.
telling you now. I'm telling you now.
Yes, sir.
Judge, can you
I want you to
confirm the
understand
name?
what's going on. Do you want to talk to an attorney before I arraign you?
Yeah, I need to know what's going on. I don't even know nothing about this.
Judge,
You
can
know
you
the ro-
confirm his name?
Yeah. Are you Terry Ackman?
No, I'm Javon Edwards.
I didn't get
Edwards.
paperwork on him.
I'm Brooke Edwards'
Okay.
grandson.
All right, we don't even have any paperwork on you, so we don't even know why they put you in that hole. So tell the deputy, we don't have any paperwork on you yet.
God bless you, Mr.
They
Oakley,
might have
man.
you in front of the wrong camera right now. I don't know.
I don't know either, brother. God
All right.
bless you, man.
Good luck.
Yes,
So
sir.
what's going on with Ackman?
Hold them on first.
Is there an Ackman out there?
He's the arraignment for.
He's supposed to be,
Oh.
He's in Wayne
Ackman's
County,
who we
but they-
want on the camera.
yeah.
Wasn't a full moon last night. All right, what am I doing with Miss Baker? Alexis Baker?
Yeah, you never gave me the file.
Oh, what did that sound? Because she never came back.
I did well.
Miss Belcher, you are all set on the arraignment part. We don't have
Thank you.
anything yet.
you-
I'll email you.
If Wayne County changes their mind, just let me know and I can sign back on.
Okay, thank you.
Thank you.
Yeah, that's what I thought.
Why messes?
Are you ready on Ackman? Or, excuse me, on Baker?
Your Honor, Mike had it on his phone. He emailed it to Heather.
What are we talking about?
Police report.
Ah,
I have it on my phone.
okay. Yeah, just for future reference, I read quick. I'd rather have your phone and be done with it, just for future reference.
Mail
I emailed it.
it.
Yeah.
Okay.
Okay, all right.
Thank you.
I'll call you up when I can. Thomas?
Keep it involved. I'm going to change it.
Thomas, who's got Thomas? Terrell.
Josh, I think on behalf of Mr. Terrell Thomas will be stating his name for the record. Mr. Thomas, please take your.
Good morning.
So, Your Honor, we've had an opportunity to retry this matter. We would like to avail ourselves of the people's plea offer. The original A means be dismissed. We'd be tendering a guilty plea to the reduced charge on, I believe, the A file of an operating while visibly.
Thank you. All right, Mr. Thomas, did you discuss your rights and options with Mr. Hadley today? You understand all that good information? You understand the possible penalty for the charge that's being added today?
Yes.
Understanding all of these wonderful things we just discussed, are you pleading guilty today freely and voluntarily to that charge? Did you drive a vehicle on November 18, 2025 in Sumter Township? Prior to driving the vehicle, did you drink some alcohol? Did you take a breath test or a blood test?
Blood test, Your Honor.
Would you stipulate to the results?
Would, Your Honor, I believe it was a .157.
I will accept the plea to the added charge. I will dismiss all three of the original counts. All right, let's see. Looks like we've got Mr. Thomas on a personal bond. We'll continue that. We'll send him downstairs to make an appointment with probation. You understand how that works? Any questions?
Your Honor, just if the probation will make a note, if there's his mother's with him, there's some cognitive, sometimes he gets a little bit overwhelmed with everything with diagnosis. It's just, I think it may be beneficial.
Yeah, Mom, where are you? Just walk him through that process. We want, if you've got any confusion, find Mr. Hadley. We don't want either one of you walking out of here today with questions. Deal?
Nothing further today, Your Honor. Look forward to seeing the court proceedings.
Okay, all right. Go downstairs, Mr. Thomas, to probation. Turner, Larry. Mr. Turner, are you going forward today without benefit of an attorney?
Yes.
You made a deal with the prosecutor. Let's see what it says. All right, I've got two files from February 15. I'm shouting, I'm sorry. One's a civil infraction, one's a misdemeanor. I understand those are both going to be dismissed because you've agreed to plead responsible to a parking ticket and pay $200. Can you pay that today? Go downstairs, get a cashier, smile, and get on your way. Sorry to keep you hanging out there. We'll do it on the civil infraction. Fayez Mossad. Yep. Mossed. Good morning. Are you going forward today without an attorney? You made a deal with the prosecutor as well? All right, so when I get caught up with paperwork, I'll see what that deal is. Okay, so you were ticketed on August 16, 2015. Wow, that's an old one. For a drove while license suspended charge. Prosecutor wants me to dismiss that charge if you plead guilty to an allow unlicensed driver to operate today. You understand the possible penalty for that one?
Yes.
Did you read your rights form? You understand those rights? You understand the options they give you? Understanding all of this, are you pleading guilty to that added charge today? Doing so freely and voluntarily?
Yes.
Did you drive a vehicle on that date in Huron while your license was suspended, revoked, or denied?
Yes.
I'll accept your plea to the added charge. I'll dismiss the original charge. What's the status of your license now, sir?
No problem. Just got on the jail on December.
Okay,
We're going city to city because
good.
I can,
Are you working? Where do you work?
literally just got off on a tobacco store in Hamtramck.
Okay, okay. All right. Anything else you want me to consider before I sentence you today? All right. Do you have reliable transportation?
Yes.
All right, I've got a lot of late fees on this file, unfortunately, so
Payment plan?
you currently,
Yeah.
we'll roll this into it. All right. So yeah, currently we're showing that you owe $867. That sound right? Okay. So on this file, it's an additional $700. So like I said, we'll roll that in. and 4 days on the court work program. Work program is assessed as an alternative to jail. You pick which days. So you can go downstairs, get this rolled into your payment plan and talk to them about scheduling your days. Do you have any questions?
No.
You sure? Good luck. Ackman, we're still looking for Ackman, still waiting on Baker. Josh, you got something?
Sir.
All right. Just confusing me. Damon Skalski Jr., Senior. How do you say it? Skalski?
Oh, yeah.
Good morning. You're going forward today without an attorney?
Yes.
All right. I'm reading this paperwork here. It looks like you've agreed to plead guilty to the misdemeanor charge of drove while license suspended, revoked, or denied from February 23, and a civil infraction will be dismissed. Is that the deal? All right. Understand that when we take your plea, that the Secretary of State's probably almost guaranteed give you 2 points, and they might resuspend you. You understand that's a possibility? Okay. You read your rights form?
Yeah.
Understood all those rights? Understand the option those rights give you?
Yeah.
And you understand the possible penalty for the charge? Are you pleading guilty freely and voluntarily today?
Yeah.
Did you drive a vehicle in Huron Township on February 23? Was your license suspended at the time? I'll accept your guilty plea, dismiss the civil infraction. What's the problem with your license? What's it take to get cleared up?
Need to deal with Hanover and take a psych evaluation.
All right, good luck there. Are you working? Where at? How long?
Since August.
Starting to heat up a little bit with the weather?
You haven't started back this.
Good, good. All right. All right, looks like you are, without this file, looks like you already owe us $520. Are you in a position to commit to some payments? Can you commit to some kind of payment plan?
Yeah, while here, I thought I already paid it, but I was confused.
All right. All right, so usually excuse me. Usually I order work program on this type of file. Is that gonna be a problem for you with work? Are you working every day right now?
Except some.
Okay. All right, we're not ready to schedule those yet. But if you pick, for example, if you schedule with us, so you're here every Friday for April, for example, can you work that out with work? I don't want to lose a job for you.
Yeah, I don't think so. My boss ain't gonna stick with it.
Okay. I'm going to give you an option. I'm going to give you a chance.
It doesn't say it. 150.
Yeah, just apply it.
You.
That's all right. Apply the bond over here.
Yeah, over there. Okay,
Yeah,
so moved
on this one, yeah. All right, so instead of the work days, I'm going to give you the option to do 30 hours of community service. That gives you a lot more flexibility because that's just charity work, right? So, do an hour here, do an hour there, it gets rained out. Goes, hook up ahead of time, set it up so that you can just show up somewhere. If you want a list of pre-approved charities, you can get that down at the front counter. All right, so I'm going to give you until, let's say May 1. All right, so if you come to me before May 1 and say, I need some time to get another 5 hours done, I'm going to say yes. If you come to me and say, I haven't started yet, I'm probably going to say no. Deal? All right, so on the money, it's $500. Go down there and add that into your payment plan. Questions? You sure? Good luck. Gene Crumpton.
The case of the People versus Evan Sherbert.
Morning, Your Honor. Raymond Cook with People.
Good morning, Your Honor. Assistant Public Defender Nicholas Bukovitz for Mr. Sherbert, who is appearing via Zoom.
Yes. Sir, can you state your name, please?
Evan Sherbert.
Thank you. All right.
I'm just requesting an adjournment for some time to finish some negotiations with the people, Your Honor.
All right. And how long are you going to be in the, Delta County?
Delta County, it looks like as of right now, it'll be till May 18th. But I'm hoping for earlier court date. They extended it out pretty far due to a different court case going on. But yeah, as of now.
You said May?
May 18th.
Okay, that's fine. It's March. Well, adjourn the matter to April 9th. If we can get it resolved at that 2026 9 a.m. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case of the people versus Avion Johnson.
Anderson is appearing on behalf of the people.
Good morning, Your Honor. Edward Lucas on behalf of Avion Johnson.
Oh, there he is. Sir, can you state your name?
Avion Johnson. Good morning, John.
Morning. Thank you, sir.
Your Honor, we've been adjourning this a few different times. I think with one more adjournment, we have wrapped this up. I do communicate some additional offers to Mr. Johnson. I'd ask for 2 weeks.
2. They're gonna be able to get the writ out. Well, no. All right. Probable cause conference then March 26th. 2026, 9 a.m. bond.
Thank you, Your Honor. Avion, I have an appointment set up with you tomorrow.
All right, thank you.
All right, thanks, sir. Court calls cases, people versus Daniel Smith.
Yes, Your Honor.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Smith, who's in MDOC but present via Zoom. Mr. Smith, could you say your name for the court?
Daniel Scott Smith.
All right, I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that the defendant will be pleading guilty to 2 charges of use of a controlled substance, both 1-year offenses. Those being counts 3 and 4. Upon a successful plea to those charges, counts 1 and 2 would be dismissed. That is the court's full understanding of the agreement.
Yes, that's the full understanding, Your Honor. We are going to request this court to consider a same-day sentence, but it's not a part of the plea agreement.
Well, why would I be confused?
So he's been incarcerated since 2023. This is an offense from September 2023. He was arrested September 19th, so about a week and a half after 2023. He's been in prison ever since, and he's done a lot in prison. He's done advanced substance use treatment classes.
And it declined to do that.
Understood.
All right. So Smith, can you raise your right hand to be sworn? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right. State your name for the record.
Daniel Scott Smith.
Sir, it is this court's understanding that you're going to be pleading guilty to 2 charges of use of a controlled substance. Those are misdemeanors punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. You understand that, sir?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
To the charge of use of a controlled substance as contained in count 3, how do you plead?
Guilty.
To that same charge as contained in count 4, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind?
Yes.
All right. You signed or had cause to be signed on your behalf an advice of rights form?
Yes, Your Honor.
You have any question regarding those rights?
No, I do not, Your Honor.
You understand that you're waiving or giving up those rights, including the rights that are contained in paragraph 5, those being your trial rights?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, not currently.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
Right, and also because you believe that you are indeed guilty of these offenses?
Yes, Your Honor.
Okay. On the date of September 9th, 2023, location of Gregory Road, Webster Township, Washtenaw County, State of Michigan, did you have cocaine in your possession?
Yes, I did.
Did you also have fentanyl in your possession?
Yes, I did.
Did you use both of those drugs?
Yes, I did.
All right, and you knew that you were using cocaine?
Yes.
And you knew that you were using fentanyl?
Yes.
All right. So I do have to advise you that if you commit misconduct between the time of my acceptance of your pleas and the time of sentencing, that misconduct is defined in the Michigan court rules. You would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, Your Honor.
So you're aware of any other promises, threats, or other inducements which led to this plea?
No. Yes, Your Honor.
No,
Well, you're not aware of any other promises, are you, sir?
No.
Okay. And have I complied with the court rule? Would it be proper to accept this defendant's pleas?
Yes, sir.
yes, Your Honor.
Court will accept the defendant's plea of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Present and report is 14A3. Probation sentencing will be April 6, 2026, 9 a.m. before Judge Fresh Hour. Bond will continue. Thank you, sir.
Thank you, Your Honor.
Court calls the case of the people versus Mamadou Diallo.
Morning, Your Honor. Raymond Cook for the people.
Ready, Judge, Torshio, official assistant public defender on behalf of Mr. Diallo, who I believe is appearing by Zoom.
Oh, there he is. Mr. Diallo, are you there?
Yeah, I'm here.
Okay.
Thank you, Judge. Mr. Scott from our office tried to meet with Mr. Diallo, but was unable to meet with him. We are requesting an adjournment so we can meet with Mr. Diallo and go over his case.
Which Bureau of Prisons where?
All
right. Mr. Diallo,
Yes,
what state are you being held in?
I'm at FCI Cumberland in Maryland.
In Maryland?
Yeah, federal. Yeah.
And so you're trying to get through to him.
Yes, Judge.
Great.
Yes, Judge.
So let's do this. Sir, are you going to be there in the month of April, you think?
Yeah, I'm not going nowhere.
Okay. All right. Then let me give you some time to try to get through to him. I'll adjourn this to April 9th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Thank you. All right. Thank you, Mr. Diallo.
All right, thank you too.
Court calls the case of the people versus Jessica England.
Assistant Public Defender Nick Bukovich, I'm appearing on behalf of Ms. Angren, who is now approaching. Can you please state your name for the record when you approach?
Jessica Nicole Anglin.
All right. Type 2 plea forms, is that what we're doing?
That is correct, Your Honor.
All right. In the case ending in 5007, it's this court's understanding that she's going to be pleading guilty to an added count to abuse of methamphetamine, the 1-year offense. On a successful plea of that charge, count 1 would be dismissed. And actually in the other case ending in 5008, it's also pleading that to that same charge with count 1 being dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the true self you got?
Yes, sir.
State your name, please.
Jessica Nicole Anglin.
Really? Strange no sounds, but all right, ma'am, it's this court's understanding that you're going to be pleading guilty to 2 charges of use of methamphetamine, correct?
Yes, sir.
Those are misdemeanors punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
Yes, sir.
Understand that while I'm taking the plea, I would not be your sentencing judge. And in the case ending in 5007, that you'd be sentenced before Judge Perry. And in the other case, you'd be sentenced before Judge Garwood. Do you understand that?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
All right. To the charge of use of methamphetamine as contained in the case 5007 occurring in January of this year, how do you plead?
Oh, guilty.
To that same charge contains in case 5008 occurring in offense date on this in October of 2025. How do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir. Yes, sir.
Cause to be signed or did sign an advice of rights form, is that correct?
The form I talked about with you right there, asked me I could sign it.
Yes.
Questions regarding any of those rights?
No.
Please look on the podium at paragraph 5. You'll see a copy of that. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Yes, sir.
Understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And because you believe that you are indeed guilty?
Yes, sir.
Starting in case 5007, on the date of January 14, 2026, at the location of 449 2nd Street, City of Ann Arbor, Washtenaw County, State of Michigan, did you have methamphetamine in your possession?
Yes.
Did.
No, not really, but yes.
About to use it?
Yes.
All right. And you knew what you had was methamphetamine?
Yes.
On the date of October 6, 2025, location of Wisteria Drive in the City of Ann Arbor, Washtenaw County, State of Michigan, did you have methamphetamine in your possession?
Yes.
Had you used it on that date?
No, sir.
All right, but you knew what you had in your possession was methamphetamine?
Yes. What time?
In looking at, now we'll look at the higher charges. The actual charge in this case and accepting your plea. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the judge would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
All right, and counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court?
Satisfied. The defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty in both of these cases. Count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered, and in case 5007, sentencing will be
March 27th at 8:30.
March 27th, 2026, 8:30 before Judge Perry. And in the other matter,
March 31st at 9 a.m.
March 31st, 2026, 9 a.m. before Judge Garwood. Bond will continue. Thank you.
Thank you, Your Honor.
Copy that I put this in. Court calls the case, People versus Rita Olive. Is she in? He's in Zoom. Got it.
Morning, Your Honor. Reading book for the people.
Ms. Olive, can you state who's her attorney?
Just rushing.
Ms. Russian.
Good morning, Your Honor.
Oh, okay, there she is. All right. Good morning, Ms. Russian.
Good morning, Judge.
Ms. Olive, can you state your name?
Ada Olive.
All right.
I apologize, Judge. I was waiting for her to walk to the podium. Sydney Russian appearing on behalf of Ms. Olive. I am sitting in for her attorney of record, Mr. Brandon Burnett, and that's with Ms. Olive's permission. Is that correct, Ms. Olive?
What did you say? I'm sorry.
Sydney Russian, remember me from last week?
Okay, yes.
And And Your Honor, Mr. Byrd is remaining on one matter. I do note that there was a substitution sent in on one of the cases and it was adjourned. So we're asking to adjourn this matter to whatever date that PCC was sent to. I think it's going to be put 2 weeks out.
Miss Olive, it's another one for Miss Olive, you mean?
Yes, she had 2 that were up for today. I believe that we are remaining on, let me get the exact correct one and I can make sure that the record's clear. I apologize.
No, it's okay. Mr. Cook, she has another.
Yes, Your Honor. So there's a substitution of attorney on the file ending in 0173. I've been informed by Ms. Olive's father today that they intend apparently on retaining that attorney on her remaining case. Also,
got it.
That one was adjourned to
March 26th, close.
Oh, okay. So it's probably 2 weeks out. My staff just informed me, believe it's March 26th.
That sounds correct.
All right. Probable cause conference in this case then will be adjourned to March 26, 2026, 9 a.m. Bond will continue. If for whatever reason we have those dates wrong, just contact my staff and we'll make sure that they match up. All right.
Thank you so much, Your Honor.
Thank you. Thank you, Miss Olive.
Thank you.
Court calls the case People versus David Brown.
And Lord Yagi, Assistant Public Defender with on behalf of Mr. Brown, who is approaching. Do you say your name for the court?
David Brown.
Your Honor, we are respectfully requesting a preliminary examination be set in this matter, and I would ask to address bond when appropriate.
Well, discovery. Wait.
To my knowledge, Your Honor.
Follow up. Yeah, I'm not sure if it exists or not, but Don is outstanding, but I'll get a picture to the defense as soon as they receive it.
All right. Would the people have their witnesses available for the 24th? Preliminary examination in this matter in person will be set March 24th, 2026, 9 a.m. for Judge Freshour. Yes, that's the bond.
Your Honor, Mr. Brown did turn himself in. He has been working with Ms. Monica through supportive connections. He did indicate that he has a place that he is going to be able to stay upon release. He is asking the court to release him today. He has access to a phone and email. He has a source of income. And like I said, he has planned through supportive connections to offer transportation around the community, including, I don't think there's any allegations of drug or alcohol in this case. But if the court was to order drug or alcohol testing, he would comply with any bond conditions the court would allow. He is being held on a cash bond resulting from, I believe, the failure to appear in back in January. And
that was on a different case, wasn't it?
That was on.
Is there a different case, or does he only have one pending?
There was a different case that has since been resolved with a trespass plea. So he's no longer held on that case. He's just held on this case.
That's my understanding. He was arraigned on 12/21. Then he had a violation on January 2nd for consuming alcohol. He failed to 129, and then on 35, he was sentenced on the other case to on a trespass charge of 5+ that was reduced down from an aggravated. So I will be bond at the court's discretion, but I also do think that alcohol is an issue. So I would ask that something on the scene be put in place, because he did act as arraignment, receive any no drugs or alcohol. Very plenty violation. He was PGT at the jail. .1.
And given the nature of the charges, both in the one that was ultimately resolved as well as this one. Court and looking at everything, I'm going to deny the request for a bond reduction. Still, bond will continue and he'll proceed. Preliminary exam. Thank you. Court does call the case. Joseph Chapman. She's, oh, there she.
Morning, Your Honor. Assistant Attorney General Carissa Williams on behalf of the people.
Morning.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Chapman, who is appearing via Zoom.
When can you state your name, please? Here. We don't have him checked in.
I did speak to him yesterday and did provide him with Zoom information, so I expected him to be here.
All did, but he's not.
Can we?
Bench warrant will issue for defendant failure to appear. Bond, how much is currently owing?
$23,404.95.
22,000.
23,404.95.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $22,904.04. Oh, I think that's right. $23,000. That warrant will issue immediately.
Thank you.
Thank you. Court calls the case People versus Kimberly Douglas.
Now, Chekhovsky for people.
And Assistant Public Defender Nicholas Bukovich for Ms. Douglas.
Go ahead.
Ms. Douglas, can you please state your name for the record?
Kimberly C. Douglas.
Thank you. All right, what are we doing?
I'm just asking for a brief adjournment, Your Honor. This case is to be dismissed once she pleads up to a case that's in circuit court. That court date is on the 19th, so I'm just asking for a couple of weeks after that.
So the case that she's going to plead on in circuit is set for March 19th?
Yes, that's my understanding.
All right, so if I set this for the 26th, will that give you enough time to?
That should give us enough time. If not, I'll get in contact with the court.
Probable cause conference will be adjourned March 26, 2026, 9 a.m. Thank you.
Thank you.
Have a good day, Ms. Douglas.
Court does call the case of the People versus Derek Hunt. This is an AG case.
Morning, Your Honor. Assistant Attorney General Carissa Williams on behalf of the people.
And Assistant Public Defender Nick Bukovich on behalf of Mr. Hunt, who's appearing via Zoom.
There it is. Mr. Hunt? We have him, but Mr. Hunt? I don't know if he can hear me or not. He's got to be having. Mr. Hunt, we can't hear you. I don't know if you can hear us. If you can hear us, wave your hand. Okay, but we can't hear you. What I'm going to ask you to do quickly, if you can, is either connect your, you have to do something, your microphone is having a problem. You're just seeking an adjournment.
Yes, I did reach out to the AG's office this week and did not receive an offer back. So I wanted to adjournment for the negotiations.
Did you reach out to contact me? I'm sorry, Your Honor.
No, it's okay.
I did reach out to you, Ms. Williams. I did reach out Sunday and send a follow-up email. Tuesday, I did see you were out of office on Tuesday, but I did send up a follow-up email.
Okay, I'll have to look. I didn't see anything. Thank you.
And I'll follow up with you after today's court date. I apologize I couldn't follow up before this morning.
But you just expect immediate response? Okay, whatever. Okay, Mr. Hunt, you can hear me, correct, sir? Not okay. So I'm going to adjourn this out. You want the 26th or the 2nd?
We can do April 2nd since Mr. Hunt's out.
April 2nd, 2026, 9 a.m. Did you hear that, Mr. Hunt? Okay. Thank you. And as you fix your mic and next time, remember, take off your hat because we're in the courtroom. Appreciate it. Bond will continue.
Thank you, Your Honor.
Is that it for the AG? One more. Oh, yes, it does. Court does call the case of the people versus Shane Morgan.
And Lori Yagi, Assistant Public Defender, with and on behalf of Mr. Morgan, who is approaching. Could you say your name for the court?
Shane Morgan.
And Your Honor, there's no offer in these, and I'm sorry, Mr. Morgan does have two cases. There's no offer at this time. We are asking that both cases be set for preliminary examination, and I would ask for respond when appropriate.
Thank you. Yeah. Your Honor, maybe I'll briefly before.
May.
Action.
Is this available the 24th? All right. Preliminary examination in these matters will be set for March 24th, 2026, 9 a.m. That's before me. As the bond.
Thank you, Your Honor. So I just wanted to note that these are two cases. One is from August 2025, but he wasn't arraigned until February 4th. The second case is from January 18, 2026. Again, it predated his arraignment, so it wasn't a bond violation. There was a delay in charging. Mr. Morgan wanted me to tell the court that he was a nonverbal. He has a pretty severe autism. He is disabled, and he was nonverbal for much of his life and childhood. He struggles with really severe sensory issues in jail. I know this court's well aware, but there's a lot of people banging on the doors and yelling, and it's a lot of sensory overload for him. He does want the court to know that he tries to be a good person in the community. He volunteers at his church and humane societies. He's also a polyglot and knows several other languages and wants to get back to his grandma, who he helps care for when he's out. So he wants me to request a release on a tether.
Any response to the people? I don't need a response.
No, Your Honor. Which one?
Then motion for bond reduction is denied. All right. Thank you. Bond will continue.
I'll up with you.
Court does call the case, the people versus Tiffany Peters.
Assistant Attorney General Carissa Williams, on behalf of the people.
Morning, Honor. Rob J.Q. on behalf of Ms. Peters. Would you state your name for the record?
Stephanie Comer.
Judge, I've emailed the Attorney General. She's been more than gracious. I need another couple of weeks regarding negotiations.
She's more than gracious to you?
Well, you're gracious always to me also, Your Honor.
No, I'm just surprised that she was gracious to you.
She was. She's very gracious. She understands the situation.
Oh, you then, right? No,
Judge, you understand, Judge, you are. I'm asking for a 2-week adjournment.
2 weeks?
Yes.
Any objection from the people?
None, Your Honor.
Thank you, Your Honor.
Probable cause conference will be adjourned to March 26th,
Thank you.
2026, 9 a.m. Bond will continue. Thank you. I think it's it for you, Madam G. Have a great day.
You as well. Thank you.
Court does call the case. People versus Cortez Fairley.
Your Honor, Raymond.
Good morning, I'm Rep. So on behalf of Mr. Fairley, Your Honor. Cortez, when you get the phone, would you?
Cortez Mar Fairley.
Judge, I met with him last night. He would like to proceed to preliminary examine this, sir. Unfortunately, I can't be here on the 24th. Could we have a date after that?
31st to work for you?
I'm sure will.
All right. People have their witnesses available at 31st.
Sure.
And discovery is completed.
Yes, Your Honor.
Preliminary examination will be set March 31st, 2026, 9 a.m. before Judge Washington. Bond will continue.
Okay.
Thank you.
Go over that stuff again. Okay.
Court calls the case People versus Derek Barron.
Good morning, Your Honor. Christie still appearing on behalf of him with Derek Barron. Mr. Barron, would you state your name for the record?
Derek Barron.
Your Honor, we are asking for a 2-week adjournment to get some more discovery and continue to talk with Senda about the case.
That objection, probable cause conference, March 26, 2026, 9 a.m. Bond continued.
Your Honor, with one issue with the bond, if I could address really quickly.
Sure.
My client is actually going through a divorce in Georgia where the complaining witness lives. He may have to attend some court hearings in Georgia. So he doesn't have a specific date yet, but I just wanted to bring it to the court's attention. If he does get a date where he does have to attend, if I could submit a proposed order with the Senda to the court for that travel permission.
And there's not going to be any objection to that. Okay. So once he finds out a date, if he's got to be there, submit a stipulated order. I'll stand off on that.
Very well, Your Honor. Thank you.
All right. Thank you. Court does call the case. The People versus Kevin Gardner.
Your Honor, Raymond Cook for the people.
Court, Your Honor, William Amadeo, P7619, with Mr. Gardner, who is approaching. Kevin, please state your name for the court.
Kevin Gardner.
Good morning, Your Honor. First, I'd like to be heard on bond, if I could briefly. I did submit a bond motion.
When was this submitted?
2 days ago, Judge.
Did we get a copy?
Yes.
What are we doing with the case?
What I said for a prelim.
All discovery is complete.
Best of my knowledge.
Are the witnesses available the 24th?
For best, Your Honor.
Preliminary examination in this matter will be set for March 24th, 2026, before Judge Freshour. As to bond.
Thank you, Judge. My client is working. He has a $500 bond he can't post right now. There was a hold out of Sanilac, and I found out what that hold was. I called the Attorney General's office. He has $8,500 he owes in child support. It is not a felony hold. It's a civil warrant out of friend of the court. I asked to be released from a PR bond and tethered. He is supporting 2 children, 14 and 16. He can get his job back if he is released.
But they would come and get him, would they not?
Sanilac will not, according to the Attorney General. They thought it was a felony bond, a felony hold, I should say, but according to Sarah Brenner, when I called her, it's just a civil warrant. So I do not believe Sanilac's going to come on that.
Bonds for the people.
Seeing the bond was sent, 1,010%. Looks like you already posted that, so there's nothing on this case that giving him. I don't know why he can't be held given that he's posted his bond.
You have his bond posted. I see the 1,000. It was 1,010%, right?
Correct.
Yep, I have the receipt. He posted. I don't know why I'm hearing a bond motion.
Well, the reason why, Judge, is because Sanilac, there was a hold in the computer system and it was believed to be a felony hold. It's just a civil hold. So my feeling is if he gets converted to a PR bond, the man will get out. Now I could deal with Sanilac's civil situation.
Would get out. He's already posted on this case.
The hold is because of the Sanilac case. The reason Sanilac was a hold was because there was a belief it was a felony hold for child support. According to the Attorney General, when I got the case, it's just a civil hold. So if he gets a PR bond, I believe he could just be released today. There's confusion from Sanilac, and I called up there. I just don't.
No, he's posted his bond on this case. I don't understand what a PR bond and the posting of a bond, why that would make a difference.
He shouldn't be held on a civil warrant, Judge. That's the issue I'm having here. And I think of a PR bond.
That's not my hold.
I know this, Your Honor. But if he does have a PR bond, I think he would just be released and we could go deal with Sanilac. The $100 bond is triggering the Sanilac issue.
How is that? I don't even know how that would.
That's what they told me on the phone, Your Honor.
Ooh, Sanilac? Well, you got to deal with them. I'm not changing this bond. Bond will continue.
Okay.
Court calls case People versus James Kearney.
Good morning, Raymond Joseph. Thank you. People.
Good morning, Edward Lucas on behalf of Attorney Senior.
Your name?
James Kearney.
Right. I think we. All right. I have a plea form in front of me.
That's correct. That's what we're doing today.
Plea form indicates that the defendant would be pleading guilty to the charge of attempted resisting and obstructing an officer, the 1-year offense. But a successful plea to count 2, count 1 would be dismissed. That's the court's full understanding of it.
That's correct, Your Honor.
Yes, Your Honor.
May I have him sworn?
Right hand. Solemnly sworn affirming testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yes, sir. State your name, please. James Kearney.
All right, sir, it is this court's understanding you're going to be pleading guilty to the charge of attempted resisting and obstructing. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that, sir? You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would sentence before Judge Barr in the 1482 district.
Sir.
And that still wish to plead guilty?
Yes, sir.
To that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind?
I understand.
Signed an advice of rights form or had one signed on your behalf?
I signed it.
Okay. Any questions about those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole? I'm sorry.
No.
Has anybody promised you anything other than what's been stated here today?
No.
Anybody threaten you or force?
No.
Doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
I do.
On January 18th, 2026, at the location of Windsor Court, Superior Township, Washtenaw County, State of Michigan, come into contact with deputies from the Washtenaw County Sheriff's Office.
Yes.
What happened that makes you think that you're guilty of this?
I really don't too much remember. I was given an order that, well, I didn't come in compliance with what they said. So.
Gotcha. What were they telling you to do?
I wasn't listening to them. So
Were the officers directing you to back up
yes.
and you were not compliant with them?
Yes.
And you believe that was a lawful order they were providing you?
I do.
Okay. Backing up from them?
Yes.
Okay. And you didn't comply with that order and stayed where you were, came toward them. Right?
Yeah.
Sir, if I accept your plea, I need you to understand if you commit misconduct between the time I accept your plea and the time of your sentencing, that you would, first of all, not be entitled to withdraw your plea Court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
I do.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 1482 probation. Sentencing will be March 24th, 2026, 10 a.m. That's before Judge Barr.
Yep.
Bond will continue. Thank you, Your Honor.
Thank you.
Court calls case of the people versus, is it Kaba?
And then on behalf of the people, Your Honor.
Good morning, Your Honor. James Fifelski on behalf of Ms. Kaba approaching. State your name.
Khadijah Kaba.
I'm missing a letter, but that's okay.
Your Honor, I'm asking for a brief adjournment. I'm still waiting for the video discovery in this case. I'd ask for an adjournment so we can obtain that.
And Your Honor, we got it.
Probable cause conference will be adjourned March 26, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case people versus Daryl Gardner.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Assistant Blood Center Davi Liba on behalf of Mr. Gardner.
Mr. Gardner, can you state your name?
Yeah, Daryl Gardner.
Andrew, I did provide a green sheet to the court requesting an adjournment order to receive some body camera.
Without objection, probable cause conference will be adjourned March 26, 2026, 9 a.m. Bond continue.
Thank you.
Thank you. Court calls the case of the people versus Shantanique Sims.
Sit down here. Your Honor.
Oh, good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Shantique Sims, who's approaching.
Oh, for me to correct something, or it's just,
Just a, it's not, it's just.
all right, very good. All right,
Your Honor, sorry, go ahead, your name.
Shanti Black.
okay, got it. That's what the right note was.
Your Honor, I just received this case yesterday. I'm requesting a 1-week adjournment for discovery.
Sorry about the
Probable cause conference will be adjourned March 19th, 2026. Yes, that's the bond.
And this time I'm going to be asking for the defendant's phone texting privileges for your vote. There were 76 calls to the victim's limited number after being arranged from the defendant's PIN. So this time I'm going to be asking your phone privileges for your vote.
Your Honor, first time I'm hearing about this morning. Obviously, I was not made aware of this before going on the record today. I don't know the nature of those calls. I'm assuming that was a bond condition, but obviously.
What I will do, and certainly after getting the information, you can request a hearing on it, but at this time, I'm going to revoke the defendant's phone and texting privileges.
And I apologize, Your Honor, it was not the list number of the police report, it was the number that we had contact with victims on.
Got it. All right. See you next week. Thank you.
I'll see you this weekend. You gotta go into that.
Court calls case people versus James Kearney Jr.
Your Honor, Raymond Cook for the people.
Blood Center Davi Liba for Mr. Kearney Jr. I have submitted a green sheet to the court. I've been advised that he's hospitalized at Trinity due to a recent shooting. I have not been able to verify that.
Here, the last time was.
Yes, sir. He has been appearing. I was told that this morning by Mr. Drukas. Apparently was an unfortunate incident. My understanding is hospitalized. I have not seen proof of that, but I was advised by Mr. Drukas of the same.
All right. You'll need to provide some information to the court. I will adjourn this out to the 26th.
Thank you, Your Honor.
2026, 9 a.m. bond continue. Court calls the cases of the people versus Raisha Anderson.
Your Honor, Raymond Cook for the people.
Assistant Public Defender Jay Bellinger on case not ending in 5330, Your Honor. Mr. Anderson up here is next to me. Mr. Anderson, can you please state your name for the record?
Raisha Anderson.
I apologize.
And good morning, Your Honor. Sydney Brushing, appearing on behalf of Ms. Henderson. I am standing in for her attorney of record, Mr. Brandon Bird. Mr. Anderson, that is with your permission. Is that correct?
Yes.
Thank you.
And Your Honor, we are just seeking an adjournment on all of these matters. We did just submit a mitigation over to Mr. Cook. He approved us for, he'd like us to refer her to the mental health treatment court. So we just need time to do that.
Got it. Is that a correct statement?
And we're joining that request.
All right. I'm not sure how long they're taking or what it is, but I'll adjourn these to April 2nd. That's the 2026, 9 a.m.
We will get that done for you as soon as possible. Okay.
Okay.
I'll work on that today.
All right.
Your Honor.
Your bond will.
Thank you, Your Honor.
Court does call the case People versus Todd Smith.
Your Honor, Green.
Good morning, Your Honor. Robert Ellman on behalf of Taj Smith. I believe she should be on Zoom. If she's not, Your Honor, I just spoke with her. If we could please pass this, I'm sorry.
I did that the last time for you.
You're very generous, Your Honor.
But you get it once in your life and you used it.
Tomorrow's my birthday?
Is it?
It is.
Oh, okay. Happy birthday.
Thank you, Your Honor.
It's all you had, but you used it. Court calls the case People versus Theodore Ankney.
It is, Your Honor.
For your own, yeah, people.
And Assistant Public Defender Davy Lebo on behalf of Mr. Ankney. Your Honor, we're going.
Your name, sir?
Theodore Ankney III.
And Your Honor, Mr. Ankney is executing a waiver. We do have an agreement where this matter will be waived to circuit court with an agreement to HIDA.
Sir, you're waiving your right to have a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of the information. We waive formal reading of the information. Stand mute and request a pretrial.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
Third at 1:30 with Judge Hamoud.
March 23rd, 2026, 1:30. Judge Hamoud. Bond will continue. Thank you.
I'll still be representing you there. So that's okay.
Court does call the case of the People versus Terry Williams.
And good morning, Your Honor. Sydney Brushing, appearing on behalf of Mr. Williams. I am standing in for his attorney of record, Mr. Brandon Bird. Is Mr. Williams in the courtroom, Your Honor?
Not checked in.
Okay, Your Honor, at this time, I know that Mr. Williams is not checked in. Would Your Honor consider passing so I can try and get in contact with Mr. Williams?
Your birthday? No, your birthday is a.
No,
Ms.
not even
Rushing.
close.
Okay, then I'm not passing. It's the only way.
But
That's
Judge,
what
it's almost
Mr.
313
Ellman
day.
said.
That's something, right?
What?
I said it's almost Detroit Day, 313 day. That should be lucky or something. It's a special day.
I'll pass it.
Thank you, Judge.
How fast did you find him? It's gonna be a long day. Court calls the case, People versus David Childs.
And then on behalf of people, Your Honor.
And Lori Agnes, public defender with and on behalf of Mr. Childs, who's approaching. Mr. Childs, can you say your name before?
David Childs.
Your Honor, in this matter, we are asking that it be set for preliminary examination.
Discovery is complete.
To our knowledge.
And would the people have their witnesses available the 24th? Preliminary examination, March 24th, 2026, 9 a.m. for me. Bond will continue.
Thank you, Your Honor.
Court calls the case, People versus Deshaun Gainey.
Your Honor, I'll tell you what I'm speaking.
And good morning, Your Honor. Assistant Public Defender Denazi Kyriakin on behalf of Mr. Deshaun Gainey.
Warnings. Afternoon.
Mr. Gainey, could you state your name for the record, please?
Deshaun Gainey.
Thank you, sir.
Your Honor, I do have a green sheet. We're asking for an adjournment today. Unfortunately, I have not been able to make contact with Mr. Gainey, but people have extended an offer. So I'd like to review that with Mr. Gainey.
26 of the second would be.
26, Judge.
Probable cause conference, March 26, 2026, 9 a.m. Bond will continue.
March? Yes.
Oh.
Straight out the gate.
Were you in a different month?
I was
with there?
I was in.
Okay, all right. No, never mind. Didn't know where you went.
Right.
Court doesn't come case of People versus Willie Collins.
Morning, Your Honor.
Lori Yagi, Assistant Public Defender with and on behalf of Mr. Collins, who is approaching. Could you state your name for the court?
Willie Collins. Thank you.
Your Honor, in this matter, we are asking that it be set for preliminary examination, and I would ask to address bond when appropriate.
Discovery is complete.
To our knowledge, Your Honor.
People have their witnesses available the 24th. Preliminary examination will be set March 24th, 2026, 9 a.m. before Judge Freshout. And that's the bond.
Yes, Your Honor. So Mr. Collins' bond was revoked because of a failure to test upon his release. This is a pretty unusual situation. So this case is an alleged Amazon package theft from 2024. He actually did a year in jail in Jackson after this allegation. And he actually, when he was released in Jackson, he reported and he tested on Monday. And there was some confusion, and I can kind of verify because there's confusion in our file notes as well as to whether we communicated with Mr. Collins that he actually did have to come here or that he just had to sign a release of information to test there and have those test results transferred here. I'm very pleased to say that the confusion will be eliminated because he is going to stay here in Washtenaw County, and he is going to be supervised on probation here in Washtenaw County, the circuit court probation. He is also willing to test at community corrections, of course. His wife is here in the courtroom. They have 5 kids. She is going to make sure that he is on the straight and narrow and help him with rides, transportation, whatever he needs. We are asking this court to reinstate his bond and allow him to be released. I don't see anything else holding him.
So he hasn't tested, or he will be testing?
So he tested in Jackson, is my understanding.
Right, but he's maybe on probation here.
Correct.
Part of his probation here that he be tested.
Yes,
Do we know how much, how often?
but
His previous bond with testing is reinstated.
thank you, Your Honor.
Melissa Yarian. Ms. Yarian is before the court with her counsel, Ms. Shy, Mr. Tranter, on behalf of the state of Ohio. We're here for a final PV hearing. Ms. Shy, does your client wish to have a hearing?
No, Your Honor, she's going to accept responsibility and admit the 3 violations.
Ms. Yarian, you understand that you are entitled to have a hearing?
Yes.
You wish to waive that?
I want to first apologize to Ms. Martinez. You've been very, very helpful throughout probation. I know I've needed to give myself more credit, like you said, because I am very capable of the things that, I haven't done that I need to do. I really have came a long way. I've had a lot of setbacks. Sitting in jail the past 2 weeks has made me realize that there is no amount of marijuana, alcohol, substance, anything that is worth being away from my son. I want to be better than my parents. My parents, bless his heart, he's passed away now, my father, but they chose drugs and alcohol over me, and I don't want to do that to my son. I want to be better than that, and I know I'm capable of that if I was given the last chance, because I'm capable. I've almost 2 years clean off meth. I did get my GED. I've overcome a lot of things. I'm capable. I just really hope I get the last chance to show it. And I'm sorry.
Well, Ms. Yarian, you have to understand that there's only so much that we can do. This case is coming up on 5 years, which is the maximum amount of time that the court is allowed to order supervision. So I'm quite frankly, I'm not out of patience, but I'm out of time. There's simply nothing else that I can do. Ms. Martinez is an excellent resource for you. So even if you're not on supervision, I think she's told you that you can still reach out to her for referral for services if that's how you choose to go. But now it's up to you. Anything else? All right, the court's going to continue you on community control at this time. I'm going to order you to serve 90 days in the Warren County Jail. You get credit for the 60 days you've already served, and then you're going to be terminated from supervision. Ms. Tranter, is there anything else?
You want a neutral term?
Neutral term.
Thank you, Judge. Nothing further?
Ms. Shy.
Nothing further.
All right, good luck to you.
Thank you.
Thank you. All right, this is case numbers 23-CR41255, 24-CR41640, the state of Ohio versus Courtney Mills. Ms. Mills is before the court with her counsel, Mr. Gibbs, Ms. Tranter, on behalf of the state of Ohio. Mr. Gibbs, does your client wish to have a hearing on these allegations of violations?
No, Your Honor, my client would like to admit the violation and waive the hearing.
Ms. Mills, you understand you are entitled to have a hearing.
Yes, Your Honor.
You wish to waive that hearing and admit to the violation?
Yes, Your Honor.
All right, the court's going to find that you have violated the terms of your ILC and of your probation. Despite this violation, the court is going to order you to continue on ILC and supervision. The court is going to order a new assessment and to be assessed for recovery court. The court has in its possession a motion signed by you and your attorney that you wish to participate in the Judge Peeler's recovery court. So I'm going to make that referral. You're going to remain in custody until that recovery court assessment is completed. I would anticipate that I believe Judge Peeler's court meets next Wednesday. So I'm pretty certain that they will have this assessment completed by then. Okay. Looks like you have 82 days jail time credit all told, right? Ms. Tranter, is there anything else?
Nothing further.
Gibbs?
Yes, Your Honor, I would just like to briefly mention, I'm in possession of a letter from a licensed counselor with the Community Medical Services signed by Mr. Eric McDougall, stating that, at the time, the client, referring to Ms. Mills, has demonstrated seriousness about her intent to find freedom from addiction, and evidence his willingness to engage in deeper, more personal issues and get to the core of the problem. So I just share that to say thank you for this opportunity. And she certainly appears to be very motivated to take these steps forward.
Well, I know that the recovery court is not easy. I certainly appreciate that you wanting to make this commitment. I think that you can do great things with Judge Peeler. Officer Bridgman will no longer be supervising you. You'll have a different officer in recovery court. It is
Dora Redis or Chandler Gouch.
okay. So you either have Dora or Chandler. They are also both excellent officers and care very deeply. So your supervision is going to change a little bit, and then Judge Peeler obviously will be taking over your case from here. So best of luck to you.
May I say one thing? I want to say,
Yes.
I'm sorry for messing up the first chance you both gave me. I just wasn't ready to be sober.
Okay, well, I hope you're ready now, because obviously, I hope you get the message that we're doing this to try to help you and not to punish you.
I see that now. Yeah, trust me, I do. Thank
All
you
right,
both so much.
good luck to you.
Thank you.
Did you do that assessment entry? I have the motion and the application here.
Thank you.
Thank you, Your Honor.
To the Hellman's clients on Zoom. His birthday's tomorrow. So we'll call it tomorrow. Yeah. Court calls the case, People versus Jeffrey Ball.
You are reading book for the people.
Sorry to wake you up. No, go ahead.
Veronica Glenn requested permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon.
Where's Cannon? And quiet. Oh, okay. She's here.
Yes.
Permission to practice is granted.
Thank you.
Goodyear, we're here for a pretrial that's resulted in a plea agreement. According to this, Ms. McQueen plans to plead guilty to counts 1, 2, 6, 7, 8. The state's dismissing counts 3, 4, and 5. Count 1 is illegal conveyance of drugs of abuse onto the grounds of a prison. That carries a maximum prison term of 36 months, maximum fine of $10,000, presumption of prison. Count 2, aggravated trafficking in drugs. That carries 8 to 12 years. It's a felony 2, $15,000 maximum fine, mandatory prison. Count 6 is possessing criminal tools. That's a felony of the 5th degree, carries up to 12 months in prison, a maximum fine of $2,500. Count 7 is participating in a criminal gang. That carries 8 to 12 years, maximum fine of $15,000 and a presumption of prison. Count 8 is engaging in a pattern of corrupt activity. That carries 11 to 16 and a half years, a maximum fine of $20,000 and a presumption of prison. Have I stated that correctly? It was an agreed sentence. The joint recommended agreed sentence is 36 months in the Department of Corrections on count 1, 3 years on count 2, 12 months on count 6, 3 years on count 7, 3 years on count 8. And all these counts are to run concurrent for sentencing purposes for a total aggregate sentence of 3 years. Judge, also an agreement that Ms. McQueen will not apply for or be granted judicial release or any other form of early release.
Judge, that is the agreement, but there's one additional thing that should have been written in there, was not. It is 3 years, but because it's there is a felony of the second or felony of the first degree, it's 3 to 4.5 years.
Okay.
I did mention that to Ms. McQueen during when I went over to form with her, though.
Okay. Count 8 is 11 to 16.5. Okay. So, Ms. McQueen, do you understand what you're doing, ma'am?
Yes,
Do you feel you've had enough time to speak with Mr. Bogan?
yes,
Do you feel you're making this decision of your own free will?
yes,
All right, I want to go over your constitutional rights with you. You do have a right to have a trial in this case. You're presumed innocent of these charges. You have a right to a trial by a judge, who would be me, or a jury of 12 people. If you have a jury trial, before you could be convicted, all 12 of those jurors would have to agree that you had been proven guilty beyond a reasonable doubt. Has to be a unanimous verdict for a jury. Do you understand that?
yes,
You have a right to confront every witness who testifies against you at trial. Do you know what that means?
a little bit.
It means that the state would be calling witnesses if we were going to trial. Those witnesses would be testifying. And since you're charged here, they'd be testifying against you. Your attorney can challenge those witnesses by asking questions. It's called cross-examination. And those questions are intended to see if there's anything that would show bias or credibility issues with the witness, anything favorable to you. Do you understand what that means?
Yes,
You have a right to have witnesses ordered to appear and testify at your request as well. Do you understand? Do you know what that means?
yes,
You have the right against self-incrimination. That means a variety of things, really. It means you don't have to prove anything. You don't have to offer any evidence. You don't have to testify. If you choose not to testify, it won't be held against you. It's basically whoever hears this case can only consider the evidence presented by the state. If you choose not to testify, they can't hold it against you for not testifying. You understand that?
yes,
Any questions about your constitutional rights?
no,
Your Honor, in this matter, we would like to adjourn for mitigation purposes.
Mr. Ball, can you state your?
My name is Jeffrey Ball.
Thank you. Why is he at our access point, not down here in the courtroom?
I'm not sure.
Mr. Ball, is there a reason you didn't come down to the courtroom?
They told me to come video Zoom.
Who told you, your attorney?
The lady who checked me in, yes, she told me to come down here and video Zoom. When I came in, she set me down. She sent me down here. Excuse me, Your Honor.
No, you're good. Don't worry about it, Mr. Ball. We know where you are. Probable cause conference. Bless you. April 9th, 2026, 9 a.m. Fine, continue.
Thank you, Your Honor.
Thank you, Mr. Ball.
Thank you, Your Honor.
Court recalls the case people versus Taj Smith. Sorry.
Morning again, Your Honor. Raymond Cook for the people.
And good morning again, Your Honor. Robert Hellman should be with it on behalf of Ms. Smith, who is present over Zoom. Ms. Smith, can you please state your name for the record?
Taj Smith.
All right.
Your Honor, we've reached a resolution in this case. We just need some additional time to get you
the paperwork.
plea form.
Ms. Smith, you get saved by Mr. Omen's birthday.
You said what?
Never mind.
Because my birthday was yesterday.
Your what? Whoa.
Yeah, my birthday was yesterday.
Why do I feel like being sad? Your birthday was yesterday. Your birthday's tomorrow. That's correct.
Tell them to look on my paper.
I'll adjourn this to March 26, 2026, 9 a.m.
Thank you.
The only reason I'm doing I'm doing that because I appreciate March babies. So we're all.
Hey, I love March Pisces.
All right. Here, Ms. Smith. Court calls the case People versus Donovan. Drongowski.
Alexander Wolski for People.
Lori Yaki, Assistant Public Defender, with and on behalf of Mr. Drongowski, who's approaching. Could you say your name for the court?
Donovan Drongowski. Thank you.
Your Honor, I have a stipulation and proposed order to release to inpatient treatment.
I'll sign off.
Okay, if the court will sign off on it, then I will ask for an adjournment
Okay.
with a green sheet that I filled out.
House count during to March 26, 2026, 9 a.m. Bond continued. Thank you. Court calls case first is Manuel Barnca.
Here, Your Honor.
This is prosecuting attorney, United People.
Veronica Glenn on behalf of Mr. Burnthouse.
Sir, state your name, please.
Manuel Barnhouse.
Thank you, sir. Doing
Your Honor, we would like to request an adjournment to allow time for discovery.
for discovery. You don't have all of discovery.
We just provided them with new police.
Got it.
Supplemental.
Probable cause conference will be adjourned April 2nd, 2026, 9 a.m. Bond continued.
Thank you.
Thank you.
Court calls case of the People versus Larry Evans.
Families and on behalf of Your Honor.
Assistant Public Defender Gia Bellinger on behalf of Mr. Evans, who is approaching. Can you state your name for the record?
Yeah, Larry Evans. Thank you.
Thank you. Your Honor, we were just asking to set this matter for preliminary examination, discovery complete to the best of my knowledge.
People have their witnesses available the 24th. You might be. Preliminary examination will be set for March 24th.
That what you want me to do?
2026, 9 a.m. before judge. For me.
Your Honor.
Yes.
If I may briefly address bond. Your Honor, my client is asking for release on PR. He advises that he is just trying to get back to work at this point. He advises that he would be able to and willing to obviously show up for his preliminary examination. This is a matter that he certainly wants to handle and take care of. He does have a place to stay locally. He's got family that supports him. Is that all correct? And
yes, it is. Response.
He also has bowled out of Detroit for retail fraud, denied and larceny in the building. This is an extremely serious case in which the victim was at the defendant's apartment trying to leave, and he told her no, threw her on the couch. He then told her to stick her sandwich before I came. She was able to use the phone to tell a friend to call 911. He then took that phone and went to the bathroom with it. She then ran to try and escape the apartment, and he wrapped his arms around her neck, pulling her back to escape by her neck and her hair. While inside, he then dragged her into a bedroom, threw her on the bed, and then strangled her, saying, "Bitch, I will kill you." He eventually stopped strangling her and told her she could leave, but when she tried to leave, he closed the door and again threatened to kill her. and then grabbed a 2x4 and raised it as it hit the victim. She has bruising, red marks, and during making herself from this instance, so I would strongly object to any.
Anything else?
Just looking at the size here versus the allegations, Your Honor, I'm not sure how all of that was very easily accomplished. Obviously, they're allegations at this point. So again, I'll just.
Had a hard time doing exactly that.
I'm not saying that he at all, obviously.
For bond reductions, bond will continue.
Right. Be in touch.
It's his birthday. And no, I'm weak. Court calls the case, People versus Deshaun Charles.
Assistant Public Defender Jay Bellinger on behalf of Ms. Charles, who appears via Zoom, Your Honor. Ms. Charles,
there she is.
For the record.
LaShawn Charles.
Thank you.
And Your Honor, we are just asking for an adjournment on this matter. We are seeking to get upper management involved for purposes of a resolution in this case.
Probable cause conference will be adjourned April 2nd, 2026. And bond continue.
Thank you very much.
Thank you very much.
Thank you.
You're welcome.
Court calls the cases of the People versus Walter Peterson.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Robert Ellman with and on behalf of Mr. Peterson, who's approaching. And Mr. Peterson, when you get up here, can you please state your name for the record?
It's Walter K. Peters.
Thank you.
Your Honor, the people have actually just made me an offer this morning. We need some time to go over that with Mr. Peterson. I would note I've spoken with him about his bond. I do know that I believe it's currently set at 1,010%. Unfortunately, that's still an amount that Mr. Peterson can't post. I'd be asking for this time a PR bond, or in the alternative, Mr. Peterson has expressed a desire to be released to treatment if that was an option on the table.
In order for release to inpatient, but his bond will continue. I'll adjourn this matter to March 26, 2026, 9 a.m.
And Your Honor, he has a misdemeanor matter in front of Your Honor as well that I believe he also has a bond on. Can I submit an order in that case as well?
For release to treatment?
Yes, Your Honor. Thank you.
Mr. Peter. Yes. Thank you. Got to keep moving.
Yes, sir. Yes, sir. Gotta go.
Court does call the case. People versus Douglas Crockett.
Al Chapo.
And it's the plug defendant for Nicholas Bukovich from Mr. Crockett, who should be appearing via Zoom.
Yes, here. Oh, there he is. Mr. Crockett, can you state your name?
Douglas Crockett. Good morning, Your Honor.
Good morning, sir. All right.
We're just asking for adjournment for a little bit of time to talk about discussing the case with my client and negotiations.
Okay, probable cause conference will be adjourned to April 2nd, 2026, 90.
Understood. Thank you, Your Honor.
Thank you. Thank you. Bond will continue. Court does call the case. People versus Bernard Gray.
Then on behalf of the people, Your Honor.
Veronica Glenn on behalf of Mr. Gray. Can you state your name for the record?
During our agree. Okay, what are we doing?
Your Honor, we would like to set this for a preliminary exam.
Sure, co-defendant. People have their witnesses on the discoveries complete, correct?
To the best of our knowledge.
Pardon?
To the best of my knowledge.
People have their witnesses available 24th. Preliminary examination in person, March 24th, 2026, 9 a.m. before fresh hour. Bond will continue. Thank you.
Thank you, Your Honor.
Let's get this one now. Court recalls the case of the People versus Terry Williams.
Again, Your Honor, Raymond Cook for the people.
And good morning, Your Honor. Sydney Rushing appearing on behalf of Mr. Williams. Mr. Williams, can you state your name for the record?
Terry Williams.
And Mr. Williams, can you start your camera?
Okay.
And also, Mr. Williams, I'm standing in for your attorney of record, Brandon Burton. That is with your permission. Is that correct? Good morning, Your Honor. Double check number 81798.
I'm trying to connect my camera. I don't know what's going on. It's not letting me turn on my camera.
All right, I'll let it pet. What are we doing?
Your Honor, we're just seeking a brief adjournment. I know that there's going to be a waiver executed in this matter. I just didn't have an opportunity to get the paperwork signed prior to today's date. So we're just asking for a brief adjournment so that paperwork can be executed.
Probable cause conference, March 19th, 2026, 9 a.m. Sir, if you appear via Zoom, you will have to make sure that you have a camera. You understand that? Otherwise, you need to be here in person.
Yes, sir.
Bond will continue. Thank you.
Thank you so much, Your Honor.
Court does call the case of the People versus, well, hold on, you guys. Thomas Maska.
Andrew Childers is paying everything. What is Judge? Portia Beast, assistant public defender on behalf of my client. Please state your name for the record, sir.
Thomas Kumasaka.
Thank you, Judge. My office has spoken to my client. They are still trying to negotiate a resolution. We are asking for a brief adjournment.
Probable cause conference will be adjourned March 26th, 2006, 9 a.m. Bond continue.
Thank you, Judge.
Court does call the case of the People versus Ryan Sitanman.
Veronica Glenn on behalf of Mr. Donlin.
Morning, Adam. Morning, sir. Your name?
Ryan Douglas Donlin.
What are we doing?
Our client would like to enter a plea.
You're just turning, my staff doesn't have the paperwork. Not the way we do it. My staff first, folks. Plea form indicates that the defendant is going to plead to count 2 the methamphetamine. That's a guilty plea. The 1-year offense upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct.
May I have him sworn?
With your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the whole truth and nothing but the truth, so help you God?
Yes, I do.
State your name, please.
Ryan Douglas Donlin.
Sir, it is this court's understanding you're going to plead guilty to the charge of use of methamphetamine. That's a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Bar in the 14A2 District Court.
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Yes, I believe so.
Well, did you sign this form?
Yes, that's the one, yeah.
Any question regarding those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I'm currently on probation, Your Honor, yes.
Were you on probation at the time of this offense?
No, Your Honor.
Anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
Doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of June 10th, 2025, at the location of Getty's Road, Ann Arbor Township, Washington County, State of Michigan, did you have methamphetamine in your possession?
Yes.
Did you use it?
Yes.
And did you know what you were using as methamphetamine?
Yes.
Sir, if I accept your plea, if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would no longer be able to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
I understand.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
I am not.
No. And have I complied with the court rule?
Defense is satisfied.
Court will accept the defendant's guilty plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
24th at 10 a.m.
March 24th, 2026, 10 a.m. 10 a.m. before Judge Barr. Bonds will continue.
Thank you, Your Honor.
Thank you.
Court calls the case, People versus Nicole Murdoch.
Michael Gandy, Assistant Public Defender, on behalf of Ms. Doctor's approach and conviction.
Nicole Murdoch.
Have before me a plea form indicates she's pleading no contest to the charge of attempted resisting and obstructing the 1-year offense. On her successful plea to that charge, count 2, count 1 would be. There's also a sentence agreement to a prosecutor's deferred, and that is the court's full understanding of the agreement.
That is correct, Your Honor. I have gone over that agreement with her rights, as well as any sentencing.
I have her
waiver.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give the whole truth and nothing but the truth stuff?
Yes, sir.
State your name.
I'm Nicole Murdoch.
Murdoch, it's this court's understanding that you're going to be pleading no contest to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court cost. Do you understand that?
Yes, sir.
All right. You understand what a no contest plea is?
Sir, I do.
2 things about it. I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentence, court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
And you understand that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Freshour in the 14A District Court.
Yes, sir.
Still wish to plead no contest?
Absolutely.
Basis for the no contest plea?
Potential civil liability, Judge.
Ma'am, to that charge, plead.
No contest.
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind?
Yes, sir.
Signed an advice of rights form or had one caused to be signed on your behalf?
Yes, sir.
Questions regarding rights?
No, sir.
Look at paragraph 5. You have a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights of.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
And this voluntarily and of your own free will?
Yes, sir.
Court has been provided and has reviewed Washington County Sheriff's report for their case number 267438. Any objection to the court having reviewed that report?
No, Your Honor.
Upon a review of that report, the court does find that there's a sufficient factual basis. The court could determine the defendant's guilt to this offense. And I do have to advise you, the time I accept your plea and the time of sentence, misconduct as defined in the Michigan court rules, would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or record.
Yes, I do, sir.
Counsel, aware of any other promises, threats, or other inducements which have led to this plea?
None from defense, Judge.
And have I complied with the court rule?
Defense is satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation report is ordered. Court sentencing in this matter will be April 6, 2026, 9 a.m. before Judge Freshtower. Bond continue.
If I could be heard on bond, Your Honor.
Mr. Bond.
Your Honor, Ms. Murdoch is, she was here last week. The court began to take a plea. There was a bond violation for a positive test. Ms. Murdoch explained what she thought could have given rise to it. I've met with her. She turned herself in as the court directed the following morning. I've met with her on this matter and discussed the matter at least twice now with her, and she fully understands that it is her obligation to refrain from doing things that the court has ordered her to refrain from doing, either intentionally or in anything that goes into her body, even by mistake, is on her. I believe that she's a good bet to comply with the court's orders moving forward. She is gainfully employed. She has a good job. Fortunately, she's been able to use PTO while she's been incarcerated this week, but that will not continue. She has a family. She lives, not a flight risk in any way, effort to give her one more chance to demonstrate to Your Honor that she is a good bet to follow all the court's orders moving forward.
Anything from the people? Defendant's previous bond, including testing, is reinstated.
Thank you, sir.
Thank you, Your Honor.
Court calls the case of the people versus Kenzie Dunn.
Michael Gaddy, Assistant Public Defender, on behalf of, take your way to the podium.
Your name?
Oh, I'm sorry, Kenzie Dunn.
Your Honor, I have submitted a green sheet. We're asking for an adjournment. Ms. Dunn has a assessment at the Sacred Heart treatment facility tomorrow. I do have a verification here. It's the Sacred Heart program that's up in Richmond, which I think is up in northern Macomb County. It looks like it's their model is a 12-step type approach. It is inpatient.
On an amphetamine of some type.
Excuse me, Judge?
On an amphetamine of some type.
You mean prescribed? Yeah, I don't believe so, Judge.
This should be clarified. So why is she testing positive for amphetamines?
Your Honor, I believe this was the initial test after arraignment. We are asking for an adjournment.
Will she test clean today?
I'm sorry?
Will she test clean today?
I'm not sure, to be honest.
You're not sure?
I haven't used, I know that, but I don't know.
I think she's, it's my understanding she doesn't know the half-life of it, Your Honor. I believe her initial test was.
That was she saying?
Or the 5th. Well,
When's the last time did you use?
It was a couple days ago. That's why I'm seeking in-house treatment. Your Honor.
Your Honor, I do have documentation here that she is seeking to address the root cause of any of this behavior. Like I said, she has an intake tomorrow. I can, it's at 1 p.m. That's in Richmond. She is here this issue today. I can offer it to the.
She tests on the 6th. She's positive on the 6th. I'm now here on the 12th. And she's using by the 10th. I have no guarantee that she's going to make it even to treatment.
Yeah, I promise you, I will have my 4 kids with me, sir, Your Honor.
She has a lot at stake.
I understand that, including her life.
Yes, Your Honor.
I'll adjourn the probable cause conference, March 19, 2026, 9 a.m. This time, the defendant's bond is revoked. Defendant's remanded.
Thank you, Your Honor.
Court calls case People versus Amber Dunson.
The judge.
Al Chabalowski for the people.
Court shall seek the assistant public defender on behalf of Ms. Dunstan. Approach to the podium. Please state your name for the record.
Amber Dunson.
Thank you, Judge. We've spoken to the people in this matter. There's a potential offer in this case, but it's going to require a large financial component to it. If we could go out at least 4 weeks, then we could see if that's even a feasibility or not, Your Honor.
Any objection?
Oh, yeah.
Probable cause conference will be adjourned April 9th. 2026, 9 a.m. Bond continue.
But Monday or Tuesday, we'll talk. Thank you, Judge.
Court calls case People versus Devon Gibson.
Your Honor.
Carolyn Foster Tucker on behalf of Mr. Gibson. Can you state your name?
Devin Gibson.
Thank you.
Your Honor, we're seeking an adjournment just for additional time to review discovery.
Probable cause conference will be adjourned March 26, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Here. Court calls case People versus Jacob Pike.
Your Honor, Raymond Cook for the people.
Jacob Pike, present.
Morning, Your Honor. Philip Kavanaugh, substituting in for the public defender. And I believe my client, Fike, is on video. And we have.
Pike, can you state your name, please?
Jacob Pike.
All right, what are we doing?
I believe that we've come to an agreement with the prosecutor. And this was just reached, so Mr. Fike has not signed it, but both attorneys have agreed, and I have talked to Mr. Fike. He is video conferencing. I believe the court gave him permission, but he is a laborer and a skilled tradesman. He is out of state right now, as he was last week. But he wants to assume all responsibility for the act. Fully employed. Children.
Here's the plea form. Plea forms have to get, has he signed, counsel, he's signed an advice of rights, or has he put an advice of rights with?
I told, honestly, I cannot say so myself.
All right.
Over.
Well, hold on.
I could.
I'm not gonna, I would normally take plea. I don't have a problem doing it, but I'm gonna put it out to make sure he's advised of all of his rights prior to entering the plea. You want an adjournment of 1 or 2 weeks, counsel?
1, quick as possible.
Will that work for you, counsel?
Yes, it will, Your Honor.
Probable cause conference, March 9th, 2026, 9 a.m. Bond continue.
Thank you.
Well, court calls case People versus Jimmy Perry.
Michael Gaddy, Assistant Public Defender for Mr. Perry, is making his way to the podium, Judge. State your name for the record.
Jimmy Perry.
He's seeking an adjournment. He wants to retain counsel.
That is correct, Judge.
How long is that going to take you, sir?
30 days, no more than, I'd say about a month, no more than a month and a half, Your Honor.
Well, I'm not going to give him a month and a half, but
Your Honor, would you consider the first week in April?
first full week or first day in April?
First full week, please.
All right, I won't adjourn it again for this purpose. You understand that, sir?
Yes, sir.
April 9th, 2026, 9 and bond continue.
Thank you, Jeff.
Thank you. Court does call the case. People versus Tania Freeman.
Michael, Assistant Public Defender on behalf of Ms. Freeman. She should be here by Zoom, Judge.
Ms. Freeman?
Hello, I'm here.
Oh, state your name.
Deanna Freeman.
Your Honor, we're asking for a very brief adjournment. I believe that the people have made an offer that Ms. Freeman wishes to avail herself of. I just need to get to the paperwork.
March 26, 2026. Bond continue.
Thank you.
Thank you.
Thank
Court
you.
calls case. You're welcome. Court calls case people versus Mamadou Kaba.
Kaba, Judge.
William Amadeo, P76194 for Mr. Kava. Please state your name.
I'm Kaba. Okay, turn this way. All right, what are we doing?
They're just setting this for a prelim.
Discovery is complete.
I believe so. Yeah, I know. Judge, I just want to make a record. We don't get a prelim today. We need it at the earliest date, please. I want my client to make sure he knows that. Since this is a probable cause conference, you can't, no, we're not adjourning anything. We're just going to the prelim.
You have all the discovery.
I believe so, sir.
You will have their witnesses available the 24th. Probable cause or preliminary examination will be set in person March 24th, 2026, 9 a.m. That's before.
Thank you.
Before Judge Fresh Hour. Bond will continue.
Thank you.
I need this.
Oh. Court calls case people versus Dallas Fritz.
And then on behalf of the people, Your Honor.
Assistant Public Defender Jay Bellinger on behalf of Mr. Fritz, who should be hearing via Zoom from treatment, Your Honor.
Dallas Fritz.
Hello.
Hello. I need a camera.
There we go.
There you go. Okay.
All right, Your Honor, we were otherwise prepared for a plea today. However, we understand that Mr. Fritz has some significant issues in Oakland County in terms of his probation that he wants to look into prior to taking the plea here to see what the consequences might be. So we would just be asking for 3 weeks. We've all been trying to reach out to his probation, including him.
Oakland. Yep. He's currently in treatment.
That's my understanding, yes.
Is that right, sir?
Yes, Your Honor.
All right.
Do you have a potential release date, Mr. Fritz?
Not as of right now, but I can get that probably today if you need it.
Okay, great. All right, thank you.
Probable cause conference, April 2nd.
Thank you very much, Your Honor.
2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, sir. Court calls versus Theophilus Smith.
Hey, Judge. Court reference to Assistant Public Defender on behalf of Mr. Smith. Mr. Be here for the record.
Theophilus Smith.
Hey, Mr. Childers and I approach briefly.
Right.
I'm just sign here for the waiver. What?
Waiving on both cases. All right, Mr. Smith, you're waiving your right to a preliminary examination in these matters?
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
Understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
Will also waive the right. Preliminary examination having been waived, defendants bound over to circuit court on the single count in both cases.
Thank you, Judge. We waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
March 24th at 1:30 with Judge County.
Why don't you give me
Oh. May
May 12th? May 12th, 2026. 1:30 before Judge County.
Thank you, Judge. If I might.
As the bond.
Thank you, Judge. Obviously, I've spoken to the people on this matter and to my client. My understanding is Mr. Smith has already had things set up through my office for if he should be released. He has worked with our social worker, Jules. He's also been in contact with Ms. Stewart in the county jail. He has CMH set up. He has housing set up. What I'm asking the court would consider releasing him on a personal bond and give Mr. Smith the opportunity to show to this court and to the people that he can be compliant on his pretrial date, should that May day, and I think that might help to get this matter resolved, and he can show that he can stay out of trouble, Judge.
Any response from the people?
No, nothing to be empty.
You're gonna be able to stay out of trouble if I let you out?
Yes, sir.
All right. Are you you're working with CMH, right?
Yes, sir.
Okay. If I let you out, Theophilus, you gotta make sure you're working with them.
I will, sir.
You'll do that for me?
Yes, sir.
I'll grant the motion for a bond reduction. I'll reduce the defendant's bond to a $10,000 personal recognizance bond. He's to comply with CMH requirement, his CMH program.
Thank you very much, Judge. Good luck to you, sir. All right. Okay. That's all. Judge.
Court calls case People versus Cedric Green, no relation.
Oh. Who's there?
Mr. Green?
Ready, Judge Torshell, Feaster, Assistant Public Defender, come back. Mr. Green, if you haven't already done so, Mr. Green, please state your name for the record.
Mr. Green, you gotta unmute. You're on a phone, so hit *6. Cedric Green, you gotta unmute. You need to hit *6 on your phone. Oh,
Can you hear me now, sir?
Yes, I can hear you. State your name.
Okay, I'm sorry. My name is Cedric Demetrius Green.
All right.
Thank you, Judge. Mr. Green was in custody. We bonded out before we had a chance to have a good conversation. I've been asking for an adjournment so that we can connect with Mr. Green, try to figure out what to do in this case.
March 26, 2026, 9 a.m.
March, what day? What was?
Bond will continue.
What's the date, though?
Today or the date I adjourned it to?
The date that you adjourned it to?
March 26.
Okay, I have I got a letter. See, the days got mixed up because they gave me a letter at the shelter, and I see Garwood on the 26th at 9.
You mean Judge Garwood?
Yes, sir.
Okay, so you need another day.
So is it March 26th?
All right, here's what I'm going to do. You got to see Judge Garwood on March 26th, right?
Yes, sir. Yes, sir.
Okay, so I'm going to adjourn these matters to April 2nd.
Okay, thank you, sir. I will be there and I will be present.
Okay, thank you, sir.
Thank you. I will be in touch with you, Mr. Feaster. Thank you, sir.
I'll be in touch with you. Yes, sir. Court calls the case. People versus Thomas Vasher. All 4 cases.
Ready, Judge Torshell, Feaster, Assistant.
Oh, no, I was going to wait.
Sorry, Judge. On behalf of Mr. Vasher, Mr. Vasher, please state your name for the record.
Thomas Vasher. Yes, you may approach.
Thank you.
Creeping up here.
Your Honor, at this point, I'm going to be asking for the defendant's phone privileges and texting privileges to be revoked. I have 23 calls to the victim's number from his and the latest call being yesterday. In these calls, the victim was mentioned by name. They talk about the charges that he had court today. So at this point, I'm going to be asking for phone privileges and texting to be revoked.
Can you respond?
No, Judge.
Defendant's phone and text privilege hereby revoked pending here.
Thank you, Judge. We're going to have a call.
Yeah, I didn't hear the chat. Okay, well, let's.
I'll give them to me.
Court calls case People versus Zariah Griffin Bills.
Your Honor, agreement with the people.
That's Public Defender Jay Bellinger on behalf of Ms. Griffin Bills. Ms. Griffin Bills, can you please state your name for the record? Always have.
Yeah.
All right. I have before me a plea form. Is that what we're doing today?
That is the plan, Your Honor.
All right. Plea form indicates that the defendant is going to be pleading count 2, added count 2 of assault and battery, the 93-day offense. On the plea of that charge, count 1 will be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That is our understanding as well, Your Honor. Is that your understanding?
Yep.
May I have her sworn?
Right hand. These about to give will be the true oath. So you got.
Yes.
State your name, please.
Sorry, Griffin Bills.
Ma'am, it is this court's understanding you're going to plead guilty to the charge of assault and or assault and battery. That's a misdemeanor punishable by up to $500 fine plus court costs. You understand that? Understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Garwood in the 15th district.
Yes.
Do you want to plead guilty?
Yes.
To that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes.
Signed in advice of right or had one cut or had one signed on your behalf. All right. Do you have any questions regarding those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yeah.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will? Yes. And because you believe that you're guilty of this offense? On dated December 1st, 2025, at the location of 114 East William Street, City of Ann Arbor, Washtenaw County, State of Michigan. What do you do on that date involving a Mr. McKeon that makes you think that you're guilty?
I got into an argument with him and he grabbed me and I hit him. Multiple times.
Pardon?
I got into an argument.
Grabbed you and then you hit him?
And you hit him multiple times?
Yes.
And that was a force that was greater than his?
No, but yes.
No, but what? Well,
I mean, yeah.
I don't know that I can accept it.
I understand, Your Honor.
So what do you want me to do?
Your Honor, I would ask that if you're willing to either pass this matter so I might have an opportunity to speak with her or give us a new date.
So your birthday?
It's St. Patrick's Day next week.
Your birthday?
It's
St.
I'm Irish.
Claiming the Irish side.
I'm Irish.
Nope, won't work. I'll give you a new date. Probable cause conference. I'll adjourn this out to March 26, 2026, 9 a.m. All right.
All right. Thank you.
Her bond will continue. Thank you. Court does call the case People versus Jason Hahn.
Alex Jablowski,
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Huff.
Jason House.
Thank you. Go ahead.
At this time, Your Honor, we will be requesting an adjournment for a little bit more time for free negotiation.
Probable cause conference. I'll adjourn to April 2nd, 2026, 9 a.m. Bond continue. Thank you.
Your Honor.
Court does call the case People versus Michael Bank. They're unable to. This is Oakland.
Michael Gaddy, Assistant Public Defender for Mr. Bank, Your Honor.
See the message from a legal assistant in Warren office that Oakland County notified them that they won't be able to get to the front of Ontario today. I asked if they gave any reasoning and They implied that there were scheduling issues. Or despite that it's not sure what happened, but I don't think that they are fully free.
Oakland signed on, but they can't bring him out. Is that? Oh, got it. Okay.
Aside from that being part of their reason for being judge, I was going to ask for an adjournment anyways, because I haven't been able to meet with him yet. We're going through their process of the virtual meetings.
Oh, okay, because you haven't been able to add it.
Which I think
second, 2026, 9 a.m.
I think I'll be required to take my first selfie in order to accomplish it.
I know. Wow. You know, Mike, have somebody take a picture of you. Yeah, that's going to be it. Court, that's called the case, People versus Edward Harris.
And then now we have the people, Your Honor. Speech.
Veronica Glenn on behalf of Mr. Edwards. Can you state your name for the record, please?
Edward Harris.
We would like to adjourn this matter for mitigation, negotiation.
I'll adjourn all of these matters to April 2nd, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Court calls case People versus, is it been Leah Winter?
Veronica Glenn on behalf of Ms. Winter. Can you state your name for the record, please?
Leah Renee Winter. Hyphen over there, Renee.
You're requesting a forensic evaluation.
Yes. We need time to, yes.
Forensic evaluation is hereby ordered. I have signed the order. I will set a competency hearing 90. June 11th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Robert Harris.
Assistant Public Defender Jay Bellinger on behalf of Mr. Harris, who should be hearing via Zoom, Your Honor.
Robert Harris?
Yeah, that's me. Oh,
That's
Robert.
you?
Sir.
Okay. All right.
Thanks.
Can you use it?
Your Honor, we are just seeking an adjournment. My client's in the middle of collecting restitution for purposes of an offer here. We're about halfway to where he needs to be at this point.
How much more time does he need? Because
Realistically, Mr. Harris, if you were to collect $2,000 more in total, how much time would that take you?
2 more thousand. It won't take long. It's like 2 more weeks. But can I say something real quick?
Mr. Harris, I just need an answer to that question. If you would, we can talk after court on the rest, but how long realistically would it take you to come up with $2,000 more?
Can you do it by April 2nd, Mr. Harris?
What is it, March? I could try that. Yeah, April 2nd.
Okay, well, let's do this. Probable cause conference. Give him a little bit. April 9th.
Yeah, that's great.
2026, 9 a.m. All right. So I'm gonna give you almost a month. Come up with that. Get it done. All right.
Yes, sir.
Thank
you,
Your Honor.
Thank you.
Thank you, Lord.
Court calls the case. People versus in Hightower.
Your Honor, being put for the people.
Veronica Glenn appearing on behalf of Mr. Hightower.
Your name?
Kenya Hightower.
Okay. What are we doing?
Your Honor, my client would like to waive.
So you're waiving your right to a preliminary examination?
Yes, sir.
We understand that that's a procedure where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor, there was an offer extended, if I can put that on the record.
Yes.
The offer was to leave up and eat on things like that.
Okay. Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following.
Your Honor, my client stands mute and we will waive formal reading of the information and we ask that you set this case for pretrial.
Waive for defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea trial. Will be set for
Judgment.
May 4th, 2026, 1:30 for Judge Hammoud. Bond will continue. Thank you.
Thank you, Your Honor.
Appreciate it.
Court calls case People versus Jalen Johnson.
Assistant Public Defender, Tanaka Kyriakin Ruby, Your Honor, on behalf of Mr. Jalen Johnson, who should be on scene.
Jalen Johnson. Mr. Johnson or Miss Johnson, I don't know. Jalen Johnson. Really?
And I spoke with Mr. Johnson earlier today.
Right, he's on the screen.
Oh, can you see him? Okay.
I can see. I can't see him. Just not talking. Chinaza, why?
I know, Judge.
You know, if this were Mr. Bukovich's client, they'd be ready to go. I'm just saying. Really? How much longer should we wait?
No, not
Like waiting for you after I call your case.
my walk is much longer. I'm just gonna ask for an adjournment today.
I know, but I gotta have the person.
I've texted him.
How'd that go?
Nothing yet.
Answering you? I'll pass it briefly.
Okay.
All right.
Be honest.
Sure.
I will.
Court calls the case, People versus Lamine Kaba.
Michael Gaddy, Assistant Public. Your Honor.
Your name, sir?
Kaba. We're asking for a brief adjournment. I have filled out the paperwork to get Mr. Kaba fixed up in the to be assessed in the mental health treatment court. If I could approach, I have the referral form for Your Honor to review. Oh, I believe this may have to go with it.
Yes. I'll adjourn Mr. Kaba's case to April 2nd.
Thank you, Your Honor.
2026. On continue.
Call these folks tomorrow morning, okay? It's this number. Okay? All right, call me if there's. All right. All right.
What? Why are you bothering Allie? Are we doing virgin case? Nah. Penitence. Court calls the case, People versus Awazi Khan. Probably said that first name wrong.
Lori Yaki, Assistant Public Defender with on behalf of Mr. Khan. Could you say your name for the court?
Oh, based on.
And Your Honor, we are requesting a brief adjournment. I have a preliminary offer. I need some more time to look into it and to discuss it.
April 2nd, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued.
Thank you.
Court calls case versus Brandon Robertson.
And Lord Yagby, Assistant Public Defender with and on behalf of Mr. Roberts. Is it everything? You say your name for the court?
Brandon Robertson.
This is Nick took his chain in, take his scarf from chain.
Leaving me.
Apologize, Your Honor.
All right.
I am requesting an adjournment in Mr. Robertson's case. A variety of reasons. I need more time to go through it, discuss it, and I think there might be some outstanding discovery as well. I haven't signed a protective order, which I know we usually have to sign to get the interview in this.
So that we haven't even gotten. Okay, gotcha.
Get a protective order over today.
Thank you.
All right. Probable cause conference. I will adjourn this matter out. Is there going to be extensive discovery in this, or?
So, but there are forensic interviews.
I think.
April 9th, 2026, 9 a.m.
Thank you. Thank you.
Court calls case versus Ed Thompson.
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Thompson. I do know Ms. Thompson just stepped out to go to the restroom, so may I go peek for her in the hall?
Fine. Wainwright is refusing. Court calls the case as the people versus Stephen Wainwright.
Stephanie Cannon on behalf of Mr. Wainwright.
She lying to. Really?
Yes, Your Honor. I was trying to claim Irish heritage as my coworkers did, but unfortunately, I don't know if I'm going to pull it off. So. So we're just asking for an adjournment of this matter, Your Honor. He already has forensic or competency evaluation orders in the other files. We just needed to get him in. So.
Oh, okay. Since he's not willing to come up. So, what I will do, what date did we set the competency?
It's in Hamut where the competency is.
Oh, it's already up.
Yes, he has one felony matter already pending in front of her.
Okay, so what I'm going to do is I'll adjourn it out to, since he's not he's refusing in this case, I'll adjourn it out to April 9th. With this one, what I would do if there are competency pending, if you want to submit that by step, indicating that it's pending, and then along with the requisite orders, and then I can sign off, reset the date.
Thank you, Your Honor. Will do.
Thank you. So hold it. What's this? Just thought that this is she here now?
This is
The
call
This is a recall.
for Johnson.
That's right. Laquita Thompson.
And Assistant Public Defender Nick Bukovich on behalf of Ms. Thompson, who's now approaching. Can you please state your name for the record?
Laquita Thompson.
All right. What do we do? You're seeking an adjournment?
Yes, I am seeking an adjournment, Your Honor. And I'm prepared to address the corrections report.
Pardon?
I said there was a note for community corrections reports. I'm prepared to address that.
And
February February 22nd. She blew numbers. 303 blows, then she took an ECG the next day. It came back.
Yes, Your Honor. In addressing the alleged violation, my client does admit to drinking on that 22nd date. It was unfortunately she did lose a friend of 24 years, someone she worked for and has known for a very long time. And unfortunately, as part of the grieving process, she does admit she did have a moment of weakness and there was a mistake and she did drink. She is working very hard on maintaining the good strides she has made in her life. She currently works 2 jobs. One where she works approximately 12-hour shifts on her feet at a manufacturing factory. She has done community service. She attends AA meetings. I actually do have AA sign-in sheet that I can provide to the court and the prosecution. She attends them both in person when she's able to and on Zoom when her work schedule does not allow her to make in-person dates. I do want to note prior to being placed on the prior to being placed on the sober link, she did have no violations on the SCLAM tether. She had to be placed on the sober link due to issues with her ankle, and that was why at the previous PCC date you allowed her to switch over to the sober link. I do note I do understand there are several late tests. However, I do want to note several of those tests she did test within 10 minutes after the time frame occurred. I think 7 of those total. And for all of those late tests, she was negative. She does, as I indicated, work on a manufacturing line. So often, sometimes there are moments where she cannot physically step away from that line due to the ongoing working process, as it would be obviously a process issue for the process of work, but also for safety down the line. She has indicated that she has reached out to her supervising agent to discuss these matters when she does have a late test. She is actually working on painting a house and was actually supposed to assign on that house today. She is doing a lot of work to improve her life, continue doing what she must. And I think it is clear that she is attempting to do with everything in her power to comply with the bond conditions. So at this time, Your Honor, I would be requesting that she have a second chance and that her PR bond be maintained.
Any response to the people?
My concern, Your Honor, is that we was on a tether and we agreed to change her to a sober link. Now she has these issues.
Yep.
And it was right about the graciousness of the court to modify those conditions. So, as I can see, there's an option.
What's that option? Lock me up.
I will adjourn the probable cause conference to March 19, 2026, 9 a.m. Defendants bond time having it.
Oh my God.
Both defendants remanded.
I have 2 jobs. I have 2 jobs. Oh my gosh.
Want me?
Got a lot of juniors and seniors today. Well, I did kind of confusing. Good morning, sir. Are you going forward today without an attorney? All right. Looks like you've agreed to pay $200 and plead responsible to a parking ticket.
Yeah.
All right. Okay, I will accept your plea to that. Oh, and you've got some bond money here.
Yeah.
Yeah, you get most of it back. It looks like, well, maybe not most, because it looks like we already put 126 of that bond went to pay off another ticket. A speeding ticket that you got on this day. All right. And then we'll use 200 of that bond to take care of the agreement for today, and then you'll get a little money back. Got that? All right. Don't happen too often. We don't like to give money back. We don't like to give money back. Yeah. It makes my eye twitch when we give money back. All right. Any questions? You're all set. Go downstairs and they'll process all that money. Have a nice day. Carl Reeves II. Mr. Reeves, are you going forward today without an attorney? All right. Let's see what we got for paperwork. Same deal. You're going to plead responsible to a parking ticket. You've agreed to pay $300 fines and costs. Yes? All right. We got a problem, you and me. You got $300 today? Not on this, you don't. I'm not giving you this deal. You already owe us $4,000. I'm not putting you on a payment. Currently, balance shows right now $4,166. So if you want this deal, you got to pay $300. It's not part of a payment plan. So how soon can you come up with $300? And I'll tell you if I'll wait that long. How soon can you come up with $300? And I'll tell you if I'll wait that long for this deal. You sure? All right. If you can do that by the end of next week, which is what? The 20th, then you'll get this deal and you can keep rolling with the payment plan on the rest of it. Understood? No questions? I'm sorry, how can you what? Go downstairs and have them run you through the computer, make sure what I've got is accurate information, right? Yeah, because the paperwork I've got is dated March 5th. So it's not like it's old information. Yeah. Yeah. Talk to Mr. Taylor. All right. So we're going to dismiss the misdemeanor. We'll do the double parking on the civil infraction, Heather. All right. Any questions, Mr. Reeves? All right. Good luck. You got that due date built in there? Heather? You got no, on the computer. Yeah. Oh, was that Baker? All right, get her up.
Also, with this young man with the dog case that we want to come back, I won't be here on the 25th.
Okay.
I'd like to be here when he's here.
You want to reschedule her?
Yeah.
Just get it with her.
All right.
Yeah. Just tell him to stick around. We'll pick a date when you're here.
All right, thank you.
Yeah.
No, because these are, satisfactory by soup.
I can't do it. That's United States, my life.
You know what, if we gotta bump this kid,
I'm sorry.
if we gotta bump this kid out for a while,
It was just.
because, yeah, we don't need a prosecutor.
Jeff.
What, we need that, Gwen. That Miss Baker, we need back in the courtroom. Thank you.
Jeff, was there a blood test on Baker?
That's what he's left this.
I'm not seeing it.
I'll stick it with the phone.
You know what it was? All right, I'm ready when you are. We need to recycle all of it. Are you ready on Baker?
She's going to get it right now. There she comes.
Ms. Baker, come on up. All right, Mr. Bowditch, your appearance for Ms. Baker.
Yeah. On behalf of.
Thank you. All right, I think we got everything we needed, except I needed the facts.
Correct, Your Honor. It's no contest.
Yep.
Search around for the facts.
Yep, and I just read them. And I'm satisfied based on the stipulation you just gave about the blood alcohol results.
0.17.
Thank you. All right, Ms. Baker, I'll accept your plea to the added charge. Dismiss the original charges as per your agreement with the prosecutor's office. So that means you're going to go downstairs on the fail to report and the impaired driving. You're going to set up a date to come back and be interviewed with probation. Based on that, they'll put a report together. We'll all look at that report and talk about that report and anything else you want to talk about, and then I'll sentence you. Understood? All right. Did I put you on a bond yet? All right. So let's do that. I'll put you on a personal bond. First condition is the obvious one, stay out of trouble, no new charges. Second one is pretty obvious, cooperate with probation and get back here to resolve this file. Third one, do not purchase, possess, or consume any mood altering substance unless you've got a doctor's prescription. Can you live with all those rules? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you screw up? Any questions? All right. We're showing that on already owed files, not today's two files, but you already owe us $534. Are you in a position to set up some kind of, you can put your hand up. Are you in a position to set up some kind of payment plan?
Yeah.
Can you do that before you leave? You gonna pay it all? Okay. All right, that'll earn you a smile from the cashier. So go downstairs and take care of that after you see probation. Michael Blade.
Thank you, Ron. You don't know, so.
Sorry, no good. Sir, are you going forward today without benefit of an attorney?
Yes.
All right, let's see what we got. So I've got one file, which is drove while license suspended revoked from November 29. I've got operated with an unregistered vehicle from that same date. And registration or plate violation misdemeanor from that same date. I understand those were setting for bench trial, correct? You understand, sir, that you do have a constitutional right to a jury trial? All right, and you're going to waive that so we can give you a bench trial? I'm not trying to talk you out of it. I just want to make sure you understand your rights. Let me give you some more information. I can guarantee that a bench trial is going to be a faster process because that's pretty much me, the prosecutor, and you or your attorney if you bring them. When we do a jury trial, first thing we got to do is we got to pick a jury. We got to pick 7 people to sit in those chairs during the trial. And that process alone adds a lot to the trial time. So it's a quicker process for a bench trial. Personally, I like jury trials because I get to schmooze people that way. But you might not want a jury trial just because it drags things out. Are you going to do that by yourself? You're sure? Have you talked to an attorney? Here's the problem. If we have a jury trial, I'm going to hold you to the same standards I hold the attorneys to. That means you got to know the court rules, you got to know the statutes, you got to know all the rules, because I'm not taking you to law school during a jury trial. Bench trial, I can give you a little bit more leeway because I'm not wasting their time. We got court-appointed attorneys here today. All right, jury trial? Okay. I don't even know. Here on April 20.
Is that fine? I just added another one on that day, so there are 2 there, 3 there.
Are you on a payment plan now with us? Okay. Are you current with that payment plan?
Today.
Say again? Well, go downstairs and make arrangements so they know, so they don't add late penalties or anything.
We have the in June, as we know.
Okay. All right. On these 3 files, we're going to give you a jury trial date. I'm going to put you on a personal bond. So first 2 conditions are pretty obvious. No new charges and show up for court. All right. Can you do that? Raise your right hand. On these 3 files, do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 on each of these files for a total of $3,000 if you screw up and violate bond? You understand all that? Still looking?
I sent Jamie out to go ask Caitlin.
Okay, sir, just have a seat. We're checking with the prosecutor to make sure she's available when we are, so we can give you that trial date. I've already got him on bond. Oh, I'm sorry, hold on a minute. We got another file here that you owe us money on. A drove while license suspended from December 1. Looks like you're in warrant status. Why?
Prosecutor here, Judge, on this.
Okay, it looks like it's just a money thing.
It was supposed to.
All right, that's part of that total you're already on, so you're okay. Yeah, that's part of that that payment plan you already have.
And you don't talk about that one.
About this one? Go ahead, put your appearance on.
Check. I have the opportunity to Mr. Blake. He told me that he wanted a bench trial.
And I explained to him that he had a right to a jury trial and he changed his mind. Yeah, no, that's fine, that's fine. She just needs you to confirm some dates. That good? All right, sir, just have a seat. We'll get you notice for that court date. And I didn't write it in the file. Brianna McCree? Ms. McCree, are you going forward today without benefit of a court-appointed attorney?
Yes.
All right, you made a deal with the prosecutor. You're going to plead responsible to a parking violation. You've agreed to pay fines of cost of $250, and both the charges that were issued on February 15 would be dismissed. Is that your deal?
Yeah.
All right, can you pay the $250 today? I'm not doing payment plans on these deals. I'll give you a due date. Tell me how soon you can come up with the $250.
So I already have a payment plan with you guys.
I know that. No.
I explained that I thought that this might be able to put $250 on for that.
Nope. Separate deal. You can run the payment plan on what you owe. That's fine. But in addition to that, tell me how soon you can come up with $250. I can do that. So are you all right with the 10th? That's a Friday. April 10th?
I'm sorry.
Are you all right with April 10th? That's a Friday. I like Fridays. Okay. All right. So if the money gets paid, then we'll dismiss the two original charges. Any questions?
So, okay, I'm gonna go because.
It's okay. That's why I'm asking if you have questions.
When I talked to the prosecutor, so he offered to.
Prosecutor's not in charge.
Well, no, that's what I'm telling you what
I know what the plea offer was, man. I got all the plea. I know exactly what the agreement between you and the prosecutor is. And I'm going to give you that deal, but I'm not going to give you a payment plan to get it. You've agreed to pay $250. That's your end of the bargain. Right. His end of the bargain is when the $250 is paid, then you get the benefit of the bargain. I'm just not giving it to you until we get the $250.
Okay, so when I pay $250,
Then the original charges are dismissed and it's the parking tickets all you got. You get the deal. I'm just not going to I'm not going to wait to see if we get our $250. Right?
I understand. I was just hoping you would be a little bit help me at the end and I want to go.
I can be lenient as hell, but I'm not going to be lenient. It's $250 and I'll give you until the 10th.
That's fine.
All right. Any other questions? Okay, have a lovely day.
And Assistant Public Defender Jay Bellinger on all cases not ending in 1665.
I didn't do that.
I don't know.
Anyway, go ahead.
And James Fifelsky appearing on behalf of Mr. Mood on Kate Bennington 1665.
Mr. Mood is appearing via Zoom this afternoon. Mr. Mood, can you state your name for the record?
I'm Giovanni Mood.
Got it.
And Your Honor, at this time, we are asking that his matters be set for preliminary examination.
That is correct, Your Honor.
Discovery is complete.
To the best of our knowledge.
Yes, Your Honor.
And would the witnesses be available at 24? All three of his cases will be set for preliminary examination, March 24th, 2026 at 9 a.m. Bond, that's an in-person hearing, sir, so you have to come down to the courthouse. Bond will continue.
What judge is that?
Or judge. Who? Me? before Simpson, before myself. Thank you.
Thank
Thank
you.
you, Your Honor.
Thank you.
Court does call the case, People versus Rachel Pichette.
Oh, you're in trouble.
Good afternoon, Your Honor. Sydney Rushing, appearing on behalf of Ms. Pichette.
Hi, Rachel Pichette.
I'll check repeat.
Your Honor, I was just appointed on this matter yesterday, so we are just seeking an adjournment for discovery to be received for me to talk about it with my client and negotiate with the people.
Probable cause conference will be adjourned to April 2nd, 2026, 9 a.m. Bond will continue. All right,
Thank you so much, Your Honor.
Thank you. Court calls the case, People versus Eric Mayfield.
Sorry, Your Honor. Lord Yagi, Assistant Public Defender, with and on behalf of Mr. Mayfield, who is unmuting himself now. Mr. Mayfield, can you unmute yourself and take the court?
Hello,
State your name.
Eric Mayfield.
And Your Honor, we are requesting adjournment. It's the first PTC. I just need more time to go over the case with Mr. Mayfield and figure out a plan.
Not objection. Probable cause will be adjourned April 2nd,
Thank you.
2026, 9 a.m. or as your invite indicates, bond will continue. Thank you. Thank you, Mr. Mayfield.
Thank you.
Court calls case of the People versus Dion Nelson.
I'll check repeat.
Judge, Attorney Feaster on behalf of Mr. Nelson, who's approaching the podium. When you arrive, please state your name for the record.
Dion Nelson.
Hey, thank you, Judge. I have tenants in the court of green sheet. We are still in review of his discovery. He's asking for a 2-week adjournment so we can further review his discovery.
Probable cause conference will be adjourned March 26, 2020. 9 a.m. Bond continue.
Thank you, Judge.
Court calls case People versus Francisco Quezada Larada.
I'll check repeat.
Assistant Public Defender Chinazi Carey, Your Honor, on behalf of Mr. Loretta, who's approaching. Take your name for the record, please.
Francisco Andres Casado Loretta.
Judge, we're asking for an adjournment today. I had a green sheet.
You had like 8 of them.
I did.
So pull one out. Fine, we'll wait for it.
I think it's in the office, Judge. I will give it right back to the court. The people have extended an offer. I've let.
Go through there with.
That's right, Judge. Thank you.
Cross client conference, March 26, 2026, 9 a.m. or as your invite indicates, we'll continue.
Okay.
All right, thank you.
Thank you. So I will say.
Okay. All right, thank you.
Yeah, we won't hold our breaths for that group. Anyway. Court calls the cases of the People versus Justin Randolph.
I'll check repeat.
Good afternoon, Public Defender Davi Leba for Mr. Randolph.
No.
No, Your Honor. Mr. Randolph is in the Livingston County Jail.
Oh, he is in.
Yes. I did speak to him yesterday. I'm going to be requesting an adjournment so that he can appear.
Okay, I will. Was he gonna get out soon or?
Expecting to be released on Monday, Your Honor.
Oh, this Monday coming up? All right.
Yes, he wasn't 100% sure, but that was his expectation.
Got it. Well, why don't I do this? Let's go March 26th, 9 a.m.
Thank you, Your Honor.
Court does call the case of the People versus Norman Reeves.
Assistant Public Defender Davi Leba for Mr. Reeves. Can you tell the judge your name, sir?
Norman Reeves. I have a plea form. That's what we're doing today.
It is, Your Honor.
The people extended an opportunity to an added or three, a sex offender's failure to sign registration. That's MCL 28.7293. That is a 93-day misdemeanor and a $1,000 fine in exchange for 1 and 2 to be dismissed. I would have had to take the plea to the.
Pardon?
I said, I think we would have to take the plea to the higher.
Higher offense of the failure to comply with reporting duties or. Okay.
Thank you, Your Honor. I believe we do also have an agreement to no upfront jail.
That is what the form indicates. All right, may I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God? Say your name.
Norman Reeves. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of failure to sign registration regarding sex offenders. Is that correct? Yes, sir. Now, that's a misdemeanor punishable by up to 93 days in jail, $1,000 fine plus court costs. You understand that? Yes, sir. And this is my case. So understanding all of that, do you still wish to plead guilty? Yes, sir. To that charge, how do you plead? Guilty. Now, you understand that by pleading guilty, you will not have a trial of any kind. Sir. You signed an advice of rights form, is that correct? Question regarding any of those rights? No, sir. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on there. Yes, sir. You understand you're giving up your right to appeal of right. Yes, sir. Are you on probation or parole? I am. All right. Were you on probation at the time of this offense? No, sir. All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? No, sir. Anybody threaten you or coerce you? Sir. You're doing this voluntarily? Sir. And of your own free will? Sir. All right. And also because you believe that you're guilty? Yes, sir. All right. Why don't we do it this way? October 24, 2024, Scenic Lake Drive. Were you an individual who would be required to report as you are a convicted sex offender? Yes, sir. Yes? Yes, sir. All right. And did you fail to report? Yes, sir. I think I'll do it that way. All right. Sir, if I accept your plea, I do have to advise you that if you commit misconduct between the time that I accept your plea and the time of sentencing, that two things would happen. One, you could not withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir? Yes, sir. All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rules?
Yes, Your Honor.
People are satisfied.
Court will accept the defendant's plea of guilty to counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be
At 9 a.m.
April 8th, 2026, 9 a.m. That is before me.
Thank you, Your Honor.
Thank you. Call, sir. Do me a favor, when you're on your way out, on the left-hand side is my probation department. Stop in there, tell them that you just took a plea so that we can start the process, okay? Sure.
What was the date of that?
April 8th. Court calls the case, People versus Cole Reynolds.
Alex Jablowski.
And Laura Yagi, Assistant Public Defender, on behalf of Mr. Reynolds.
Not true.
Not here. And also there's a violation, so probably not expecting him. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000 cash surety. That warrant will issue immediately.
Thank you.
Court calls the case, People versus Alan Rogers.
Afternoon, Your Honor. Raymond People.
Stephanie Can on behalf of Mr. Rogers. Mr. Rogers, could you please state your name for the record?
Alan Rogers. Yeah. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates the defendant's going to plead to an added count 3 abuse of a controlled substance, a 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. defendant is agreeing to participate in substance. That's court's full understanding of the agreement.
That's correct, Your Honor. Record, the people did receive documentation from defense counsel showing that he has participated in that treatment now, so I believe that conditions.
Okay.
That is correct, Your Honor. He has successfully completed.
Let's have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, please.
Alan Rogers. All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of a controlled substance. That is a misdemeanor, punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that? Yes, sir. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and that you would be sentenced before Judge Washington in the 14B District Court. Yes, sir. Still wish to plead guilty? Yes, sir. And to that charge, how do you plead? Guilty. Now, you understand by pleading guilty, you'll not have a trial of any kind. Sure. Signed in advice of rights form, is that correct? Sir. Question regarding any of those rights? Oh, sir. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on there. Yes, sir. I understand you're giving up your right to appeal of right. Yes, sir. Are you on probation or parole? Oh, sir. Has anybody promised you anything other than what's been stated here today on the record to get you to plea? No, sir. Anybody threaten you or coerce you? No, sir. You're doing this voluntarily? Yes, sir. Of your own free will? Yes, sir. And because you believe that you are indeed guilty of this offense? Yes, sir. On the date of July 19th, 2025, at the McGregor, Ypsilanti Township, Washtenaw County, State of Michigan, did you have cocaine in your possession? Yes, sir. Had you used it? Yes, sir. Do you know what you were using was cocaine? Yes, sir. All right. Sir, between the time that I accept your plea and the time of your sentencing, if you commit misconduct as defined in the Michigan court rules, you would, first of all, not be permitted to withdraw your plea, and the court would no longer be bound by any sentence recommendation or evaluation. I understand that, sir. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
The court has.
All right, court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Sentence investigation and report is ordered at 14B. Probation sentencing in this matter will be 16th, April 16th, 2026, 10 a.m. before Judge Washington.
Your Honor, may I briefly address bond?
Down.
He is out and he is doing really well out, Your Honor. Since he's been out, as you know, he has successfully completed his inpatient treatment. Currently, the court has him on GPS tether, which the court tends to do when we put them in treatment. My client has had no subsequent violation. He currently has stable housing. He has family members. My client is just asking that the tether come off, Your Honor.
Any response from the people?
No, Your Honor.
What city is he residing in? I'm in Taylor. You're residing in Taylor? Yes, sir. If I take it off, are you going to come back? Yes, sir. Yes, sir.
He will, Your Honor. If the court recalls, he came back. He
How
was
was she
here.
answer that?
I just want to assure you,
What are
Your Honor,
you driving or what?
I'm just so proud of him and the things that have happened since you've let him out. That's all, Your Honor. I'm just proud of him.
Me too. I didn't answer the question. Is she driving?
No, his
Okay, I'm just saying. I didn't know. No.
Frankie drive.
Yeah.
Yeah, his sister is, Your Honor.
Yeah.
I do have a driver's license, so I don't
know, but with your, because I'm just.
Yes. Bond will continue. The defendant, however, may be released from the GPS tower.
Thank you so much, Your Honor.
Thank you.
Yep.
Court does call the case of People versus Arissa Rodriguez.
Okay, well, I'll speak to the people.
And public defender from Ms. Rodriguez, who is here by Zoom, I believe, Judge.
She's here.
Hi.
Hello, state your. Yes, we can hear you.
Okay. Arcia Rodriguez, how's it going, Judge Simpson?
It's going well. Thank you for asking.
Your Honor, we're asking for a brief adjournment to discuss this matter further with the people and with Rodriguez for the reasons stated in the green sheet.
Got it. Probable cause conference will be adjourned April 2nd, 2026, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you.
Okay, thank you. Thank you so much.
You're welcome, Ms. Rodriguez. Court calls case of the people versus, is it Mapendo Ratayesir?
Yes, sir.
What you said, Judge? Torshell speaking, public defender, on behalf of my client, who I see soon.
Yes. Sir, can you repeat your name?
Mapendo Ratayesir.
Thank you, Judge. I did speak to Mr. Childers on the case. Looks like we have an offer in this file. If we could adjourn it for a couple of weeks so I can talk to my client and see about a potential resolution, Your Honor.
Probable cause conference will be adjourned March 26, 2026, 9 a.m. Bond continue.
Thank you, Judge. I'll be in touch, sir.
Court calls case, people versus Skurlock.
People.
Assistant Public Defender Jay Bellinger on behalf of Ms. Skurlock, who appears via Zoom. Ms. Skurlock, can you please state your name for the record?
Destiny Skurlock.
Thank you, Your Honor. We are in the midst of an investigation right now with our office, and it's just taking a little bit of time. We are getting kind of close on. I would just ask for 3 weeks.
Probable cause conference will be adjourned April 9th.
Thank you.
2026, 9 a.m. Bond continue. You, ma'am. Court calls case, people versus Ashley C.
Alex Chapelowski.
And Assistant Public Defender Nick Bukovich on behalf of Ms. C, who's appearing via Zoom.
Oh, there. State your name, please.
Ashley C.
At this time, Your Honor, I'm requesting a brief adjournment to have everyone with time to talk to my client about this case.
Matter will be adjourned to April 2nd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
All right, thank you. Court does call the case, people versus Benny Sims Jr.
Assistant Public Defender Davi Lebo for Mr. Sims. Mr. Sims, could you take your hands out your pockets until the court time?
Miss Benny Allen Sims Jr.
All right. And he's waiving.
Yes, no, we've reached an agreement for a resolution in circuit court.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed in which you committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
You will also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of the information. We waive formal reading stand mute and ask for a pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for May 4th, 2026, 1:30.
Thank you.
For Judge Hamoud.
Thank you, Your Honor.
And bond in this matter will continue. Mr. Sims, thank you for coming back.
Thank you.
Oh, no, that you showed up bright and early, right? We realized that you weren't in the right, well, you were here early.
Yeah, I'm trying to stay up out there, stay up out of jail, man. I'm doing good. I'm
trying to stay out of jail.
Yeah.
So you know what?
Going back. I ain't going.
So I sent Mr. Allen out to tell Mr. Sims that he didn't need to be there till 12:30. So he came back out.
Sir.
You remember what you said?
Well, which one? Her right there?
No. Do you remember what you said to Mr. Allen?
Oh, I said, can I go outside and
he said, oh, cool. He said, I'm gonna go outside. Yeah, okay. All right.
Hey.
All right, fella. You take care.
Y'all too.
Court calls the case, people versus Laura Smith.
Michael Gaddy, assistant Apple, Ms. Smith. Approaching judge. State your name.
Laura Smith.
You're requesting an adjournment.
Yes, Your Honor. Ms. Smith is seeking, I believe she will be assessed and hopefully admitted to the Saginaw Treatment Court, Saginaw County Treatment Court next week on the 17th, and then the 19th, I think, is the
appointment date.
Yeah, her appointment dates. We did submit some testing documentation to the courts. I was able to contact TRICAP and get those dates.
Okay. All right. She's good. So basically, the 3 and 3/9, she did have testing. What happened in February?
I was on the SCRAM program and
Ms. Tranter, for representing the state of Ohio, does the state have a position?
Yes, Judge, we do. My understanding is that Mr. Clutter has paid the $700 that was outstanding, so that's no longer an issue. The issue from the state's perspective is the nature of the charge. I understand that this was an NGRI finding.
No.
No?
Wrong case.
Am I looking
This
wrong?
one, he was granted ILC and completed ILC. There was a previous case from 2018 where there was an NGRI finding, but
Okay.
that one is not before the court today.
Okay.
If you look at the, if you look at the
My
recorded
mistake then.
probation, that one is the 2018 Warren County case.
Yes.
That one, that we're not here on that one.
Okay.
This is a 2023 case for obstructing official business. He was granted ILC, has completed ILC.
Okay. In that case, I have no position.
Oh, okay. Well, that's good to know. Mr. Clutter, is there anything else that you have to say?
Not at this time. I understand we're on a different case than the 2018 case.
Yeah, that one's a little bit more complicated,
It
and
is.
I'm not going to give you any indication today as far as how I would rule on that case if that was before me, because that's a different circumstance.
Right. We've already talked about that in a different court case with Steve Kilburn was there.
Yeah.
And you, yeah. we
I see. And I told him I wasn't comfortable
wasn't
sealing
ready
that.
for doing that right away.
Yeah.
So that's okay.
So we're on the same page with that one.
We're on the same page.
So let's just deal with the 23 case. Let's deal with that one. Okay. Anything else you want to tell me?
I have a job now. I've got a job, Camp Kern.
Oh, good.
Yeah. It's probably the best job I've ever had. It's even better than the Scenic Rivers job I had that I lost before this case. So I've come a long way, Your Honor. I've made a lot of progress in my personal life.
Just
things
you
that-
have that report. I don't have that report in front of me.
Yeah.
I'm sorry.
The past couple of years have been tough, very tough. Obviously, because I was in jail for 101 days. However, I overcame, and even after losing my job with the state, which crushed me, I was able to bounce back. And I just got hired on a couple weeks ago with Camp Kern, and it's absolutely the perfect job for me.
Okay.
And I really love the job. I've had great support from family, from probation, from my agency with Greater Cincinnati, with my team of people that I've put together that have allowed me to, succeed. And I've been set up for success. I've set myself up for success.
Are you currently on medications?
Yes, sir.
And
Yes,
you're,
Your
and
Honor.
you're fully compliant with those
Yes, sir.
medications?
Yeah, absolutely.
Again, I can't make you do this, but certainly I know sometimes when you're on those medications, you start feeling better. Say, well, I don't need them anymore. I would just strongly encourage you to make sure that you always have that conversation with your treating physician or psychiatrist to make sure that that you follow his or her recommendations.
Yes, Your Honor.
We agree on
absolutely.
that?
Absolutely. And just to reiterate, one of my medications is an injection. I am on a 6-month dose of that. It's something that is always in my system. It's an antipsychotic. So that is always in me. And I don't take a pill every day for that one.
Okay.
That's the one that matters.
Yes.
And
yeah.
that's the one that, for these cases that happened, I lapsed a little. I was on the same month of which I was supposed to get a re-injection, but there was some miscommunication between me and the mental health agency, which was Solutions before. Now it's Greater Cincinnati. It's much better with Greater Cincinnati. I have more people to keep me in line there, and I have a therapist, which is great. I have a great doctor. I have a nurse. I have a person with employment services that help me. There's also another lady that her name is Sarah. She's with Community Alliance. My family, I have family and friends. Everybody keeps watching me. I've had to kind of put a lot of my family and my friends in their place because they're concerned. Everybody was concerned, and rumors would get spread about me. So rumors would get spread, and they were essentially not true, and everybody would. It's a long story. It's hard to explain, but there was rumors made about me that weren't true that made more people concerned. And it just compounded. And then everybody was like, oh my gosh, Bela's this and that, which I was really okay. I wasn't.
Right.
And then we were forced to call crisis. Crisis showed up. And when crisis showed up, they showed up with law enforcement. I did my best to handle that, which I made a mistake. And I walked through my neighbor's house to get kind of get away, he wasn't home at the time, but my neighbor and me we're really good friends. Anytime I don't have a microwave, anytime I go to his house, it's an open door policy. So when I went to his house, walked through his house, it was nothing that I didn't do every day, and I was charged with breaking and entering.
But that charge was not. I mean, you were.
Yeah,
not,
that was dismissed.
Yeah.
That was dismissed. So yeah, that's why I ended up in jail.
Right.
That's the date. I did 101 days for that. So just saying, my medication is always in me. Plus, I like the other medications that I have. I like those. One's a Abuse Bar, which is anti-anxiety. That really helps me not worry as much. And I've also been taking another medication that's motivative.
Mm-hmm.
And so I kind of like those medications, and I don't have any. Can't tell of any side effects either. So
okay, well that's good.
As of right now, I've recently started. I just recently added the motivational. It's an antidepressant.
Okay. All right, Bela, I want to make a finding today that the offense of obstructing official business was dismissed on November 25th, 2025. I will further find that there are no criminal proceedings currently pending against you, that the charge that you were on aisle that was dismissed, you are eligible to have that sealed, and your interest in having this record sealed is not outweighed by any legitimate government need to maintain this record. So I'm going to grant your request. If you'll give me just 1 second, I'm going to file this. Done. All right, I'm going to print out a copy of this entry granting the sealing. Mr. Logston will give that copy. Again, we'll talk and revisit that other issue down the road a little bit. I just need to make sure that.
Do you have a time?
I don't know that I have a time frame, Bela. I mean, I guess I just need to make sure I feel comfortable that you're complying with, you know, the medication and staying out of trouble, things like that. Okay.
Yes, sir.
But we can talk about that one again down the road. The other ones, the burglary that you mentioned from 2024 that was nollied.
What does that mean, Your Honor?
That means nollie means that you were indicted, but that's the county. Oh, that is our case. I guess you're eligible to have that one sealed too. Do you have that report in front of you?
The report?
Yeah. No, here, take this one. But I'll circle the ones, because this looks like it's our case. This, the one I'm circling, this first one from 2024, you're eligible to have that one sealed. And then the other one's the one we've been talking about. The third one is from Middletown. That was dismissed too, but you can go to Middletown and have that one sealed. But this one is my case, 2024, the burglary that was nollied, which meant that you were indicted, but then it was ultimately dismissed.
Right.
So that one you can refile under that case number and do the same thing we did here today.
Oh,
and then
okay.
and then
that was included.
No, you got to do it under each case number. Yeah, sorry about that.
That's okay.
Come back and see me in a little bit, okay? On
Okay.
that one, and then we'll talk. And again, we'll talk down the road. I'm not going to give you a time frame that I feel comfortable in talking about the 2018 case, but we'll get there. Okay.
I want to just let you know the program that with Hannah Martinez that she put in place.
Yeah.
The Forge program. I successfully completed that, and I have a Forge coin now.
Well, good.
Community, what's it? Fostering opportunities for community engagement. That's
Nice.
what that was for.
Well, congratulations on that. Have you told Hannah that?
She's the one that gave me the coin.
Okay. Have you visited Hannah today?
She was out here just a minute ago, but she had to go to the jail. She was going to be in here today.
Yeah.
But she had to go to the jail since I had to take some time and pay my. Thanks.
Well, good luck to you. I'll see you on that other case, the 2024 case. I'll see you on that because I'll grant that one too.
Okay.
The 2018 case we'll talk about down the road.
Will there be more fees for that?
Yeah, I don't control the fees. Yes, there probably will be. Is it maybe a $50 filing fee, whatever? I don't know. You have to check with the clerk's office on that.
Would you recommend? Well,
the 2024 burglary case, I will grant that one. So you want to get that one sealed?
Okay.
So I'll grant that one, but the 2018 case is the one I'm still mulling over.
You're right. And that one probably need to get in touch with Steve Kilburn again.
Probably best to talk to Steve.
I've already asked him.
Although, you know, I'm going to tell you right now, Bela, whether you hire Steve or you come in yourself, the answer is going to be the same. I don't know that hiring Steve is going to, again, I'm not trying to talk you out of hiring an attorney. You're always free to do that. But I don't know that it's really going to make a difference to me if you have an attorney standing with you or like you today, you come in on your own and do it. The answer is going to be the same. And it's just, and I really can't, I just need to gauge my comfort level with doing that.
Okay.
That makes sense?
Absolutely.
Okay, sir. Good luck to you.
Thank you.
All right, Mr. Costa, just looking to put in. Are you going to give me something?
Yes. Oh, I thought I give you both of them. Yeah, please. Oh, okay. I got you. What did we find out about Miss Diefenbach's case?
That's
She is right here.
Oh, she's hiding back
She's
there.
hiding, yes.
He's here?
Here she is.
Roxanne, what are we doing with that case?
I'm gonna set it for a bench trial, Judge.
So we're gonna need to waive a jury?
Yeah.
Get him in here. Let's do it.
I'll go get it.
All right, thank you. got too many moving parts up here, Mr. Bogan.
No, sorry, I didn't remember to bring this up in chambers.
All right, this is Mr. Costa, correct?
Yes, Judge.
All right, 25 CR 43236, the State of Ohio versus Charles Costa. Mr. Costa is before the court with his counsel, Mr. Bogan, Ms. Nicholson, on behalf of the State of Ohio. Mr. Bogan, you wish to be heard.
Judge, just briefly, it's my understanding, excuse me, he did test negative today. And he has, aside from that initial testing positive, he's been compliant with the conditions of bond. He's been showing up to court. He's been in communication with me. And obviously, with this case possibly heading to ILC, ask you to take that in consideration with him being on the box.
Ms. Nicholson, does the state have a position?
Your Honor, he's been on the monitor for 30 days approximately. We'll defer to the court.
All right. Was he placed on the monitor coming out of arraignments?
Yes, sir. When I got released, they put me, oh, sorry.
That's, yeah, I just.
Yes, that was the order out of arraignment.
Okay. All right, Mr. Costa, I'm going to grant that request and I'm going to order the monitor removed today. I'm going to caution you that you are underage. You are filing for ILC, and I do not permit anyone to use marijuana or THC in any form while on supervision, and that includes the condition of your bond. Do you understand what that means?
Yep, don't use marijuana. Yes, sir, I understand.
So you're responsible for anything you put into your body. So if you test positive for marijuana, you will either be taken into custody or put back on the monitor. Are we clear?
Yes, sir.
All right, you need to go back down to court services. I'll send them a removal form, and you need to schedule your assessment with them, okay?
Yep, I appreciate it. You're saving me some money
All
doing
right.
that. Thank you, sir.
Thank you, sir.
Yep.
Before I do that, do you mind, Mr. Bogan, if I deal with Mr. Manning over here?
Oh, sure, Judge. And Judge, you mind if I just use the restroom while you're doing
Please.
that? Thank you.
All right, this is case number 26CR43323, the State of Ohio versus Daryl Manning. Mr. Manning is before the court with his counsel, Ms. Diefenbach, Ms. Tranter, on behalf of the State of Ohio. Is there do you have a written?
I have it here.
Oh, if you mind
I was
giving.
going to hand it to him. May I approach?
Please. All right, thank you. All right, I have before me, Mr. Manning, a document called a jury waiver. Is that your signature, sir?
Yes, sir.
Did anyone promise you anything or threaten you in any way to get you to waive your right to jury?
No, sir.
Are you under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
Do you understand that you are entitled by law, it is a constitutional right that you are entitled to have your case determined by a jury of 12 people?
Yes, sir.
And if you want, we will impanel a jury of 12 people, and we will require the State of Ohio, the prosecutor's office, to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or they are required to find you not guilty. Their verdict must be unanimous. All 12 must agree. Do you understand that?
Yes, sir.
You understand?
Yes, sir.
Okay. So what you're doing here is you're asking the court, you want to waive your constitutional right to trial by jury, and you want your case to be heard by the court. In other words, I would be the one determining whether the state has proven your guilt beyond a reasonable doubt. Do you understand that?
Yes, sir.
And you've talked this over with Ms. Diefenbach?
That's correct.
This is how you wish to proceed?
Yes, sir.
Okay, very good. Is this Mr. Tranter?
Yes. it's fine. Sorry.
Anything from the state?
No, nothing from the
Ms.
state.
Diefenbach, is there anything else?
He did want me to ask if you might consider taking him off the ankle monitor.
All right, let me cover that next. Okay, with regard to the jury waiver, the court's going to make a finding, Mr. Manning, that you've made a knowing, intelligent, and voluntary waiver of your right to trial by jury, and I will accept that. I will have Ms. Diefenbach contact my assignment commissioner and set this for a bench trial.
Thank you.
Now, with regard to the monitor, anything you wish to be heard on that?
Yes. He actually does have a place to live. The problem is he hasn't been able to prove it because the lady with whom he's going to live has not been able to come in and verify it. So that's the only way he can go home with an ankle monitor on him. So he wanted to ask you to remove the ankle monitor. Right now he's living at Genesis.
Ms. Tranter? Do you have anything?
I think, was this a court order for him to be at Genesis?
No,
Where did we?
I volunteered.
He volunteered.
Okay, I couldn't remember where we were. I don't really have an
Well,
issue, Judge. I mean,
I would say he did voluntarily go there, although it was set up by Officer Wilkerson. Is that fair? While you were in jail, you reached out to Jamie Wilkerson from Court Services,
I asked, yeah.
and then she had you assessed by Genesis, and they found you appropriate, and you had a bed available, right?
Yeah, for mental health, yes, sir.
This is our first pretrial, correct?
Yes,
It is.
How long have you been at Genesis?
I don't know.
Since the 2nd of the month.
Are you on a monitor at Genesis?
Yeah, I'm not allowed to go anywhere.
Yeah, so that's
Right.
10 days.
I can't go nowhere for 55 days.
Let me do this. I'm going to take that under advisement at this point in time. I need to check with Mr. Manning. I'm going to check with Court Services or Community Corrections and find out how compliant you've been. You've only been on it for a few weeks. Is that fair?
Correct.
Okay. I think that might be a little bit premature at this point in time. Ms. Diefenbach is going to get this scheduled as quickly as possible, I assume.
Yes, sir.
So I'm gonna at this point, I'm just gonna wait and decide this later after I've had a chance to talk to Community Corrections. Okay, sir?
Fair enough.
All right, very good. Is there anything else, Ms. Diefenbach?
No, sir.
All right, thank you for your time.
Thank you very much. Thanks, sir.
Yeah.
Logistics issues with partnership also choosing one.